The Appellate Division First Department is now in session. Good afternoon, everyone. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar, so please listen carefully. People versus Sharif King.
Claudia Troop, present, Your Honor.
Jody
Six and one.
Yes.
Jody Danzig for the people, Your Honor.
5 minutes. Holman versus Schroeder is submitted. DRB Capital versus Hilario is submitted. Board of Managers 825 West End versus Grunstein.
Milad Baduhi for the petitioner appellant.
3 and 1.
Yes, that's right.
Respondent Cheryl Corman, 3 minutes, Your Honor.
Thank you. Malone versus City of New York for the appellant.
Craig Sheldon for the appellant. I think we were allocated 5 minutes and 1.
5 and 1. For the respondent.
Ingrid Gustafson appearing on behalf of the city, Your Honor.
5 minutes. Schwartzbard versus Kogan is submitted. LePatner Project versus 320 West 115th Street for the appellant.
Jason Stern for the appellant, Your Honor.
5 and 1. And for the respondent.
Tom Mulaney for the respondent, Your Honor.
5 minutes.
Thank you.
People versus Tyrell Myers for the appellant.
Anjali Padmanathan on behalf of Mr. Myers, Your Honor.
6 and 2. And for the respondent.
Samuel Goldfein for the people, Your Honor.
6 minutes. Devereaux and Associates versus Tufo is submitted. Lewis versus Thomas is submitted. People versus Jorge Smith is submitted. Pantaleo versus O'Neill is submitted. 14th Street Medical versus Epstein for the appellant.
Jonathan Rogan for the appellant, Your Honor.
6 and 2. For the respondent.
Kenneth L. Kuttner for the respondent, Your Honor.
And you have 6 minutes. There's no cross appeal here, so it's just
correct,
6 minutes.
Thank you.
Yes. BGC Partners versus Avison Young for the appellant.
Emily Milligan for the appellants.
5 and 2 for the respondent.
Nate Kritzer for the respondent cross appellant.
5 and 2.
Thank you.
Nimble Ventures versus Graves for the appellants.
Good afternoon. Chris Harwood for Mr. Graves.
And Adam Cole for Liquid Digital.
Okay, for Mr. Harwood, it's 6 minutes. For Mr. Cole, 6 minutes. Now for the respondent.
Wesley Mullen for the respondent, Your Honor.
8 minutes. Caro Home versus 181 Westchester Avenue is submitted. Sokolov Arts versus Nur Ashki is submitted. Counsel, before we begin, please remember, as always, that we have your briefs, we have your record. We are fully familiar with the facts of your case, so please go directly to the points, the most important points that you wish to make. Also, as is customary, please don't speak when a justice is speaking. This is particularly important, of course, during our virtual arguments, in order to hear the questions that are asked and hear one another. Finally, please keep your mics muted unless you are speaking. That's very important because we get a lot of background noise sometimes. And of course, thank you for your patience and your cooperation. The first case is People versus Sharif King. Ms. Troop.
Good afternoon, Your Honor. On behalf of Sharif King, I'm Claudia Troop, and Mr. King is currently serving a 7.5 to 15-year sentence for a non-violent Class C felony. This sentence was recognized by the sentencing court itself as severe, and it is far out of line with what this court has deemed appropriate in similar cases, many of which we've set forth in our brief.
Why is this severe here? Why is this severe?
Well,
I know the court called it severe, but why isn't a severe sentence appropriate for this defendant? He had a weapon. He assaulted his counsel.
He did not. Well, the assault of the counsel came during the proceedings of this case, and that case is a separate case, which this court is going to be asked to review the sentence in and to gauge what sentence is appropriate for that conduct. But
So
what
he
if-
was charged separately for that offense?
He was charged separately with that, and by coincidence, we were assigned today to that case, and that record will be before you completely. And at that time, that is when the gravity of that offense should be determined in connection with the sentence overall.
But counsel,
here,
I'm sorry, this is Justice Moulton. The sentencing judge initially sentenced him or gave him a sentence of 4.5 to 9 years, correct?
yes,
If he complied with certain conditions. And
Yes.
one of the conditions was not getting arrested again.
yes,
And then he assaulted his defense attorney. And
yes.
also another condition was that he was supposed to show up regularly to court. And it seems like the record supports the sentencing judge's conclusion that he was in fact using every means in the book to avoid showing up in court.
It is
So
true.
why
We're not
is that
arguing.
sufficient? I mean, to negate the initial sentence and
We're
impose the more strict one.
We're not arguing that there was no breach, Your Honor, but what we are saying is that an enhancement from 4.5 to 9, which is already a severe sentence for a case of this like this. If you look at the cases and the sentences that have been upheld and modified by this court, even in cases of breach, like People versus Gant last term, where the defendant it was a grand larceny case. She breached the terms of her agreement. The court enhanced and this court reduced to 2 to 6 from 4 to 12. We see those things over and over. People breach, but there should not be an enhancement to 7.5 to 15 for a non-violent C-level property crime. That's just not in line with the types of cases and the types of sentences that have been imposed, particularly in this case where Mr. King has a history of severe mental illness, and he should not be punished for his inability to comply with the terms to this extent, for his inability to comply with the terms of the agreement. Now,
May I ask you, go ahead.
Go ahead.
Was Mr. King incarcerated or was he released?
He was
during this period?
incarcerated.
He was
During-
incarcerated. So when the court talks about him not coming into court, he was either claiming that he was ill or was objecting for some reason.
Right.
Isn't that correct?
Correct. Yeah, it wasn't as if
So-
he had absconded from the proceedings
He
entirely.
was within the control of the correctional facility.
Yes, he was. And I just wanted to touch on the mental illness. Now, the prosecution argues on this appeal that there's not a well-documented history of mental illness, but there absolutely is on this record. First of all, the pre-sentencing report itself talks about a prior pre-sentencing report documenting a mental health history back to 1993, including inpatient hospitalization at Creedmoor and Elmhurst mental hospitals, as well as suicidal attempts.
So
Again,
it wasn't make-believe that he had some psychiatric history? This was confirmed?
This
in
was
the pre-sentence report?
in the pre-sentence report, which references a prior pre-sentence report before this incident that dates his mental health history back to 1993. So the fact that a prior pre-sentencing report references the mental health history before any reason to fabricate in this case supports that there was a documented mental health history. Also, in the federal proceedings, Mr. King testified under oath that he had been diagnosed with bipolar disorder and schizophrenia and stated that he was currently taking Risperdal, which is a psychotropic medication to treat bipolar mania and schizophrenia. Also, the defense attorney stated that a letter had been sent to the prosecution below, and this was not disputed, outlining Mr. King's history of mental illness and setting it forth in some detail. And it was never contested that that letter was not received. So yes, Mr. King breached the terms of this agreement, but he's a mentally ill man, and he should not be enhanced to 7.5 to 15 beyond what this court has deemed acceptable in similar type cases.
And let me just clarify, was there a weapon involved in this case?
No, there was no weapon involved in this case. These were all property crimes. Mr. King has no documented history of using weapons. His prior convictions relate to also possession of a forged instrument and
Counsel, this is Judge Owing. I have a
Yes.
question. Did your client have a 7:30 hearing?
He did have a 7:30 hearing. There was, and he was found fit, but there were obvious problems with the 7:30 hearing, obvious mistakes. The 7:30 report in several places referred to Mr. King by a different name. It stated that he had no known criminal history, which it's beyond dispute he had a criminal history, and it also said he had no known mental health history. the examiners did not attempt to verify a mental health history, and it was a very cursory proceeding before it was concluded.
Was his attorney present?
His attorney had been ordered by this court to be present, but he didn't show up originally. And then it was put off, and then eventually it was messed up because Mr. King didn't want to wait until his attorney appeared. And so eventually part of it went forward with his attorney being present, but part of it was without his attorney being present. And I'd also just like to mention the appeal waiver, why that is no good. The appeal waiver is no good for 4 distinct reasons. First, it was mentioned only cursorily by the plea court. The nature of the right to appeal was not explained. It was also not explained that if Mr. King did not get the benefit of the bargain, it was put in terms of him having to waive his right to appeal because it was a beneficial plea bargain. But it wasn't explained that if he didn't get the benefit, which is what happened here, he didn't get the benefit of the bargain. He got 7.5 to 15 rather than the 4.5 to 9. It wasn't explained that the appeal waiver would carry forward to an enhanced sentence. Also, the written waiver misrepresented the scope of the appellate division's review authority, saying the appellate division only had the authority to review issues of law and fact, mistakes of law and fact, or errors. That's not true. That's not what we're asking for here. As your honors are aware, the appellate division can substitute its own discretion for that of the trial court without any, in an interest of justice, excessive sentence claim without any violation or mistake of law. And finally, the written waiver also said that it withheld that Mr. King could raise the issue about the sentence, the legality of the sentence, which has been found to be confusing in terms of an excessive sentence claim. So the waiver is not a basis for denying review. There is not a single case that either party has shown here that even comes close to the sentence that Mr. King is serving for a property crime, for possession of stolen property, identity theft. We routinely see sentences of 2 to 6, 2 to 4. That's in the realm, or 3 to 6. That's in the realm of what a property crime gets, not 7.5 to 15. This sentence does nothing but warehouse a mentally ill defendant for years beyond. And I just want to talk about the practical import of this sentence. If you do not reduce the sentence, Mr. King does not CR until 2025. That means he will serve 10 years.
Counsel, this is Judge Owing. I have to ask you a question.
Sure.
In terms of your client's, perceived mental illnesses, I have to ask you this question. What do we have in store for him if, in fact, we agree with you? What are we talking about here?
In terms of what kind of support
what kind of assistance is he going to have? I have to ask that question.
Okay. Well, we have a reentry program at my office, which he'll have access to. We have a full-time social worker who can help situate him, and for his reentry, he'll have that support.
And we're assured your client will be amenable to these services, correct?
I believe so. Yes, I have no reason to believe he won't be.
Okay, thank you.
Let me just, I thought I heard Justice Owing say that it wasn't verified that he had mental illness. Did you say that the pre-sentence report cited to another pre-sentence report that indicated that he did have he was in a facility? He did have a history of mental illness?
Yes, it said this pre-sentencing report, which is presumed to be accurate and reliable, said documented a previous pre-sentence report, which referenced a mental health history going back to 1993 and mental health hospitalizations at Creedmoor and at Elmhurst Hospital and suicide attempts.
Thank you. Ms. Danzig?
Thank you. May it please the court. This is Jody Danzig for the people, Your Honors. Your Honors,
Counsel, is a severe period of incarceration appropriate here for this offense? A severe penalty, because that's what the court said.
Well, the question, Your Honor, is 7.5 to 15 fair and appropriate for this offense? And it's certainly—
Well, the question is the one I asked, actually, which the court said was severe, and that's what he gave. So I'm asking you, is a severe penalty appropriate here?
It is appropriate, Your Honor, given the nature of the defendant's crimes, his lack of—
These are property crimes, as counsel has said. Property crimes of this nature even aren't usually met with this kind of sentence, 7.5 years. 7.5 to 15, I should add.
Your Honor, it's because of the extent to which the court found that Mr. King had taken advantage of everyone who had come into his orbit within the years leading up to his
The court is so he seems to have, well, it's documented that he has a history of mental illness. And while the court, the 730 exam found that he was competent to proceed, that doesn't mean he was not under the effects of his existing mental illness. And he indicated that he was taking medication. So when you say that he brings everybody into his orbit, that may well be a person who was under a mentally ill person. It may be part of his illness that was affecting his behavior, in other words.
Your Honor, it's worth noting that the two doctors from Bellevue who interviewed defendant in February of 2017 specifically noted in both of their reports that defendant had no known history of mental health treatment.
Is that the report that named somebody else, that referred to a different individual under a different name and one who had no history? Is that the report you're referring to?
No, Your Honor. This report does not have that error in it. What it does state is that
the other report had that error in it. So this is a different doctor?
These are the two doctors who interviewed defendant at Bellevue as pursuant to the Article 730 hearing. Both of them indicated in their reports that defendant had no known history of mental health treatment ever. And more than that, they noted that defendant was the only person who had ever raised any concerns about his competency. And he had not tried to challenge his competency in the concurrent federal case.
So are you saying that that the pre-sentence report was wrong? Did anybody challenge that as wrong? Did your office say that the court shouldn't rely on that?
Well, what I'm saying is I'm questioning what it's based on. The present pre-sentence report is based on defendant's own self-serving, unsubstantiated statements and vague statements that he suffered from bipolar disorder and schizophrenia, and that he was taking a medication for one or both of these conditions. But these statements were simply not substantiated. And even if they had been, defendant's claims fail for so many other reasons, Your Honor, particularly because the waiver of defendant's right to appeal was made knowingly, intelligently, and validly. The waiver was preceded by the trial court's urging that counsel speak fully to defendant about the nature of the right to appeal and what it entailed and what the consequences of waiving that right would be. The court also
did the waiver speak to the issues with regard to whether or not what would happen if the sentence promised was enhanced, and whether or not what his rights were with regard to that?
I'm not sure about that, Your Honor, but the court twice orally emphasized to defendant what the consequences would be if he failed to comply with the conditions of his plea. The court was extremely clear about that.
The conditions you're talking about are coming to court, but he was incarcerated, right?
Well, the circumstances of his failures to appear were that even though he was within the custody of the state, he was refusing to appear, and he appeared to be, as the trial court concluded on multiple occasions, he appeared to be malingering. He appeared to
Counsel,
be.
The bottom line I want to get to again is that this was a property crime. Do you have any other case, similar facts to this, where a person gets 7.5 years, whether he comes back to court or not? And I know you may refer to the fact that he assaulted his client, his attorney, but he is prosecuted separately for that. I mean, even that, he's prosecuted, and obviously he's sentenced already. Those factors suggest a severe sentence?
Your Honor,
that's what the court said here.
I can't point to another case because even the trial court regarded this case as absolutely unique on its facts. This was a case where the defendant's breaches were so extraordinary that the trial court remarked on multiple occasions that it had never seen anything like this before. So many instances of the defendant appearing to be malingering and not appearing for his scheduled sentencing proceeding, and then the assault on the attorney. By the time before defendant was sentenced, not only had he been charged and arrested, he had been indicted for this crime, and eventually later.
Sounds like someone with mental illness to me, but in any case, I understand your argument. Thank you. Do you have anything else? Sorry, did you have something else?
No, Your Honor, except for one thing. I just wanted to remind the court that defendant is not alleging in this case that he was not competent to proceed. That is not a claim.
That wasn't suggested. At least to me, I didn't understand that was the suggestion.
Yes, Your Honor. Thank you.
Thank you. Ms. Troop?
Just a few things. The 730 exam is demonstrably inaccurate for the reasons Your Honor stated. The reports say he has no criminal history. There's nobody disputing that he has a criminal history. The waiver did not make clear that in the event of a breach, it would still be in effect. And for that reason alone, in addition to the other three I mentioned, it can't be enforced. And there was nothing in this case. He was in the control of the court. The court could have sentenced him the first time he didn't show up. There's nothing unusual, unfortunately, or unique. A lot of mentally ill people have difficulty complying with the terms of the agreement. The sentence should be reduced. It's unduly harsh. Thank you.
Thank you. Thank you both. Board of Managers Board of Managers 825 West End versus Grunstein.
Good afternoon, Your Honor.
Good afternoon.
This is Malad Badouhi for the appellant.
Yes, go ahead, begin.
Okay. Your Honors, this is an appeal over a provision in a condominium's bylaws that the trial court, most respectfully, erroneously.
So this is a little unusual in that the bylaws here seem to indicate that the Board of Managers gets to choose everything. It's very one-sided, it seems.
That's true, Your Honor, and that's how it was drafted. It's in the court. It's in the board's discretion to decide how best to resolve a dispute with its unit owners. That is how I interpret these provisions.
So what is an owner supposed to do after they go to civil court, to the part that deals? Thank you, HP part. And you know, because of the mold and whatever, and there's a stipulation. And apparently it's not resolved.
Well, they can.
And then the Board of Managers can choose not to go to mediation.
That's true, Your Honor. Well, here's the thing. If the unit owner wants to proceed down the ADR path, as I call it, which is a 1-2 punch of mediation followed by arbitration, then they have to first request the mediation, and the board, yes, it's in the board's discretion whether to allow the dispute to go down that pathway. But the unit owner can always commence an action in court. That's their right, and that's something that the bylaws and this provision of the bylaws allows for. And in fact, they did commence an action in court. They had the option, they had the water leak dispute. They had the choice. Do we want to review this as a mandatory arbitration clause and require the board to arbitrate this dispute, or do we want to commence an action? They commenced an action in civil court.
But the thing was, the HP parts are set up to deal with exactly this type of a situation where there are repairs that need to be done. My understanding was that they went to the HP part, they got some kind of an order from the court that your client did not comply with those orders. The unit owner had to go back into court to move for contempt before she could get any kind of a plan for remediation or renovation or repair from the landlord. When that still didn't pan out, she then attempted to go the mediation route. Your client did not want to mediate. Now, there's a part of the contract that says, or the bylaws, excuse me, that says any dispute that cannot be successfully mediated, well, then can go to arbitration. Well, this could not be successfully mediated because your client wouldn't go to mediation. So shouldn't the client then have had an opportunity to proceed to arbitration?
Well, Your Honor, first of all, the timeline is a little bit different. There was a stipulation that was entered into in the HP action, in the civil court action, and the board complied. The board repaired all of the leaks that were within its control to repair. There were other leaks that were within units that the board wasn't responsible for. The unit owner moved for contempt long after this arbitration had started. The demand for arbitration had started, and the trial court denied their motion for contempt. So that's because we had done all that we could. But with respect to your second question, which really touches on what the meaning of successfully mediated is. And I believe the meaning of successfully mediated is you tried mediation and it didn't work out. It's not that you didn't try mediation. And in fact, if the drafters wanted to draft it the way Your Honor just interpreted it, they could have just said any dispute between the parties must be arbitrated, like every other mandatory arbitration clause that's ever been enforced. They specifically included the word successfully mediated for a reason, and that's to tie that provision back to the first section, the mediation provision. And the reason that's clear to me, at least, is that there's references in the first section to litigation. There's a reference in section 4 to recovery of legal fees in the event of a lawsuit. Why would you include any of those things if this was a mandatory arbitration clause? You could have kept it very short and sweet, one sentence, any dispute between the parties must be arbitrated. Okay, you could maybe add another sentence that mediation is at the board's election, but so 2 sentences in total. That's not what we have here. We have 5 sections devoted to this. And my whole point here is at absolute bottom, this is not clear that it's a mandatory arbitration clause. And if it's not clear, I'm not here to tell you that this is crystal clear for one side or the other. And if it's not clear, it's not a mandatory arbitration clause. That's what this court has ruled. That's what other courts have ruled. That is really the ultimate takeaway here. We can disagree on what these terms mean. It's obviously not the most well-drafted provision out there, but you can't strip away a party's right to the courts with a provision like this. It's not clear and unequivocal. There's certainly more than one interpretation. That's not unequivocal. That's equivocal. And there's a case law out there that says the provision must be susceptible to one interpretation. And we've already established that there are multiple interpretations of this provision.
Thank you. Ms. Corman?
Yes, good afternoon, Your Honors. This is Cheryl Corman for the respondent, Sarah Grunstein. First and foremost, I think we need to take this back to the real first inquiry that should be had as to whether or not the issue of arbitrability is actually something that the arbitrator could have decided. And pursuant to the case law, under the arbitration provision here, where it specifically incorporates the rules of the American Arbitration Association, which provides that it is for the arbitrator to determine these issues as to the first issue. Is to
how do we get to that? How do we get to that point where we're here looking at a clause that, first of all, the court usually decides what's arbitrable, but here we're looking at a bylaws that say the Board of Managers gets to decide whether or not this goes to mediation.
Okay, I have 2 responses to that. First, generally the issue of arbitrability is for judicial determination unless the parties clearly articulate otherwise. And the cases all cited within our brief show that
this is hardly clear, as counsel has said. This is hardly clear.
I think if we're going to just look at this and say this is unclear, then we're going to have to fall back on general provisions of contract interpretation, where an unclear.
But let me just say something else. You're overlooking the fact that you're talking about arbitration. They're talking about mediation. They didn't choose to go to mediation. It says that at the election of the Board of Managers. So they get to choose whether they want to go to mediation. If they don't want to go to mediation, then you don't get to arbitration.
Well, that's
so
where
aren't you ahead of
No, that's where I disagree, Your Honor, respectfully. The decision whether or not to mediate pursuant to this provision, the decision whether or not to mediate is within the sole discretion of the board. That we all agree upon. But once they decide that they're not going to go to mediation, there's no successful mediation. And at that point, the broad arbitration provision, which says that any dispute between the unit owner and the board shall be submitted to binding arbitration,
But first it says any dispute that cannot be successfully mediated. It doesn't say any dispute in which mediation is rejected or not elected.
I think that it's two sides of the same thing. And I think, yes, this is very unclear, but I think that the way it reads, quite honestly, is if there's no successful mediation, then you go to arbitration. So if you
you're interpreting if it cannot be successfully mediated to incorporate the possibility that one side declines to go to mediation, and therefore there couldn't be a successful mediation because there can't be a mediation at all. Did I get your interpretation of that?
Exactly, Your Honor. I believe that Section 2 requires the parties to proceed to mediation in the absence of a mutual agreement to the contrary, and if there's no successful mediation. Or else you're reading this entire arbitration provision out of the bylaws, and it's clear that that's the intent.
Well, it's not read out of the bylaws when the Board of Managers gets to choose. If they choose to mediate, then essentially they're choosing arbitration, because if they mediate and it's not successful, then they have to arbitrate. They have to. It says shall. But you're reading of the second section of the bylaws. It sort of ignores the use of the term elect in the first instance in the Section 1, and it clearly says they get to elect, and you're just ignoring that because that's a choice. But it's not okay.
I'm sorry. Are you finished?
No, I'm saying, okay, you go ahead. I think you got my point.
It clearly says that they can elect whether to mediate. That's all Section 1 talks about. It's then Section 2 that talks about arbitration in the absence of a successful mediation. I don't believe that at the discretion of the board carries all the way through to the rest of the provisions. It's certainly not clear. And if it's not clear, then pursuant to regular principles of contract interpretation, it needs to be construed against the drafter, which is the board here. So I think that it's
Counsel, this is Judge John. Taking what you just said, that statement, then, if it's not clear, then there's also a case law that says there's no mandatory arbitration, because the argument that you're making is that there is mandatory arbitration here. And if there's an ambiguity, we have case law. We have a lot of case law that says if it's not clear, there's no mandatory arbitration.
Each of those cases, particularly the ones that were cited in briefs by the petitioner, when they're talked about that it's unclear, those are the interpretation of whether or not there was a broad or a narrow provision. And the court said that if it could be interpreted two ways and there's a narrow way to interpret it, we're going to interpret it the narrow way and then not hold that it's subject to mandatory mediation. That's how I read those cases. But I think that that's actually quite clear on the face that the decision to mediate is the only thing that's within the sole discretion of the board.
So I have this question, though. I'm reading that first section here, and it talks about unit owners agreed first to try in good faith to settle the dispute by mediation. That, to me, I read that and I'm thinking, there are two scenarios going. There are two situations here. One is where unit owners are disagreeing with other unit owners. And then you have a situation where the unit owner disagrees with the board. And when it becomes unit owner versus unit owner, they already agree that they have to go to mediation. They have to go that way. And if that is not successful, then you go to arbitration. That, to me, is what that says. When you're dealing with unit owner versus unit owner, we have a clear path as to where it's going. But when you have a unit owner versus the board, there's a different spin there, because then it becomes the election of the board as to what path they want to take. Do they want to take mediation, which then ultimately goes to arbitration, or do they just say, no, we're not going that way. We're going to go another way, which is, in this case here, we want to go to court. So that's what's happening here. There are two scenarios. Am I reading this wrong? Or
no, there are absolutely two scenarios, but I don't see that they come out to a different result.
Well, you do agree that in Section 1, it's the unit owners amongst themselves agreed to go to mediation, and then that's where it goes, right? I mean, that's how you read that strictly the way it says, right?
Correct, but then there's also reference to the Board of Managers and that it's at the election of the Board of Managers.
Yes.
So in that
Yes,
section,
yes,
so that
yes.
section's contained there also, which talks about at the election of the Board of Managers,
Right.
that you need to then, that they have the option to then go to mediation. And that's all that provision says.
Yes,
And
they
then
have
if
the
you look-
option, which means if they don't take the option, what happens?
Then there is not a successful mediation. And then we go to section 2, which says any dispute that cannot be
That's
successfully
really
mediated.
stretching it. That's really stretching it when you're saying there's not a successful mediation. How can you say there was not a successful mediation if there was never mediation to begin with? It just didn't happen. It just didn't happen. I mean, so the term success, from what I remember in grammar school, means that something actually was there was an effort made. There was no effort made. It's done. It never happened. Okay, I got it.
I'm not sure that I don't agree that that's necessarily the only way to read this. And I think that you would just be taking it out of context to do so. But I just want to also
Thank you, Counsel. If you would just wrap up.
Okay, I just want to quickly make a point about the HP proceeding. First of all, that issue was not preserved on appeal, and this is not the type of strict legal issue that this court should be reaching when raised for the first time on appeal. Whether or not something was waived is inherently a factual issue. And if you look at the two proceedings, going to the HP proceeding, it's not the typical foray into litigation. It's just brought for the purpose of correcting conditions or to hold the board in contempt. Whereas if you look at the items that were sought in connection with the arbitration, it was for damages, retroactive common charge adjustments, and other things that just don't fall within the ambit of an HP proceeding. And so going to the HP proceeding should not be deemed a waiver of the arbitration. So
Thank you.
For questions, I'll rest on my brief.
Thank you, Counsel.
Thank you.
Mr. Bedoni, is it? Bedui, I'm sorry. You're muted. You're muted.
That's right. It's Bedui. Don't worry. Anything close enough, I respond to.
Well, maybe you shouldn't. Maybe you should start requiring people to say it.
Well,
anyway, go ahead. You got 1 minute. So go.
Okay. I'll be very, very quick. I don't want to repeat myself. I think everything is clear here. I 100% agree with you, Justice Oing. The successfully mediated to me means you tried and it failed. You didn't have to say successfully mediated if you in fact meant what the respondent is saying that the provision says. You could have just said any dispute must be arbitrated. Successfully mediated must mean you tried and you failed. And that's how and I think that those two words link it to the first section. So second point, it's highly, highly, highly unusual for a set of bylaws in a condominium to have a mandatory arbitration clause. And I think what we're touching on here is the drafter of this provision was struggling with coming up with a way that the board could retain the power to choose how to resolve a dispute with its unit owners to be cost effective or for whatever reason there may be for the board to do that.
But the next time when your client comes to you, and I assume this client did not come to you, you'll draft a clearer provision in the bylaws, won't you?
100%. My firm did not draft this. We will make it 100% crystal clear forward, and with much
Counsel. So yeah, my point is that you heard what I was asking respondents, that there's two scenarios going on here. You have unit owner versus unit owner, and then you have unit owner versus the board. When it comes to unit owner versus unit owner, they have to go to mediation. They agree to go to mediation, so that there's no way of saying no. But when it comes to unit owner versus board, the board gets to choose. I don't want to go. You can try to force me to go, but I'm not going. And that's the end of it.
That's 100% correct, Your Honor. There's two other really quick points, if Your Honors don't mind.
If they're less than 15 seconds, because you already got a lot of time.
Less than 15 seconds. The issue of arbitrating arbitrability, I don't need to tell this court. In the In re Stein case, Justices Renwick, Kapnick, and Moulton were on that panel. You know exactly what the issue is there. Sorry, Justice. You weren't on that panel.
Right there.
We'll tell you what it is now, Judge Owen.
Yeah. Thank you both.
Okay, thank you.
Thank you very much.
Your Honor.
I felt left out.
Malone versus City of New York.
Craig Sheldon for the appellants.
You may begin.
Oh, okay. Well, to really understand this case is to understand did the Department of Transportation just establish a boarding zone like a bus stop? That's simple. We say what they actually did was, under the guise of establishing that bus stop, was restructure the entire carriage industry. They
So,
deprived.
counsel, you're, as the party that's seeking nullification of this new regulation, you have a heavy burden, right? Because you have to demonstrate that the new rule is unreasonable, that it's, doesn't have a rational basis. How do you do that when the rule, just let me ask you, how do you do that when, of course, DOT is there for the very purpose of regulating traffic? And then this particular section, the administrative code, expressly authorizes them to designate these specific locations and it says shall be the sole locations where passengers can board these horse-drawn carriages. So how is that unreasonable?
Well, we do that in several ways, Your Honor. We say that the court shouldn't close its eyes to the ancillary effects of this rule. So, for example, the DOT adopted a rule that's actually harming the health of the horses every day. The horses are being...
Well, I think there were some affidavits from people who established that that wasn't the case.
And there's no evidence in the record to the contrary. The DOT did not put any evidence in a trial that lining up horses downhill was healthy. We have unrebutted evidence that this is harmful to the health of the horses. And just because they can establish a bus stop or a boarding zone doesn't mean that the court should close its eyes to the fact that these horses are being harmed every day that they're forced to stand in this boarding zone. So
they have there's a longer area where they will be now, right? Isn't it the linear aspect is greater than it was?
Well, this is exactly the opposite, Your Honor. Because the DOT has no expertise whatsoever in the horse carriage industry, they set aside insufficient space for all of the horses. Before the rule, the horses used to line up all along Grand Army Plaza and Central Park South. When the DOT set aside the new boarding zone, they intentionally did not allow enough linear footage to accommodate all the horses. So now think about this.
So I thought the linear footage of this rule was greater than the last. I thought it was 1,010 feet before, and I thought it's 1,050 feet now. Is that accurate?
Well, you're accurate in a sense, but that's where the DOT's lack of expertise on this industry led it to blunder. Under the previous rule, horses were not limited to marked boarding zones to line up. And lots of horse carriages lined up outside the marked boarding zone.
Well, isn't that one of the very things that could lead to accidents and everything else when they're beyond the zone that they intend that they're supposed to be in?
There's no evidence of that whatsoever. In fact, the evidence is to the contrary, that the horses lined up where they were lined up along Central Park South and Grand Army Plaza did not lead to accidents. Now, in the opposition brief, the DOT tried to put in some extra evidence that they didn't put in court to try to remedy that, but that doesn't work. You can't introduce new evidence on an appeal. There's actually no evidence whatsoever that the pre-existing boarding zone introduced any risk. So now we have a situation where there's not enough space for all the horses to operate. And just think about it, you've got a carriage full of passengers, you take your ride, and there's no space to discharge those passengers. That's the rule that they enacted. We have a carriages with passengers in them that we can't discharge because there's no space for it. Now those carriages have to go around and around, kind of like a jet circling JFK. And this is because the DOT has no knowledge of the industry. Why wouldn't they have set aside enough linear footage for all of the horse carriages? It just doesn't make sense to me. But it's because they blundered, they wouldn't meet with us.
Mr. Sheldon, but didn't in fact several different agencies combined in regulating this issue? And while the DOT might not have as much expertise as your clients in the horse carriage industry, they still know about traffic, and there's other agencies that they combine with all to sort of come together, use their various expertise to reach the result that they did, which sort of go back to Judge Renwick's first question, how can we really determine that there was not a rational basis when they all got together to create these new rules?
I wish that was the case. I wish with all my might that that was the case, that in adopting this rule, the DOT had taken input from the Parks Department or from the Health Department. All there is a letter from the mayor's political appointee to the DOT saying, please adopt boarding zone rules. But there's not a scintilla of it.
So Counsel, Mr. Sheldon, this is Judge Owing. So I'm hearing your arguments. If it's just a matter of not having enough space, isn't it then that maybe we should go back to the DOT and say we need more linear footage to do the disembarking, right?
I couldn't agree with you. We've tried. We've tried. This is actually, I mean, this is not in the record now, but obviously we've tried to no avail. And we tried before that rule was adopted.
You're not arguing that being placed in the park is something that you don't want to be. You're not arguing.
We have that argument as well.
Okay. It's not just the linear footage. You don't want to be in the park either.
The couple of fundamental problems of being in the park is A, the city council says we can operate our horses from, I think, 10 a.m. to 3 a.m. every day.
I'm glad you mentioned that. Well, then how do you explain the section 20-381.1F in the administrative code, which says that this section shall not be construed. This is the section that you're relying on in terms of the time that you're allowed to be in the park. And it says at the very end, this section shall not be construed to permit the operation, parking, stopping, or standing of any horse-drawn cab in any area, any time, where such operation is prohibited by any other law or rule. So if another law or rule gets passed, then you don't have that argument doesn't fly very far.
Well, I think the answer to that is they should have established a zone outside the park where we could have had the full statutory authority of the city council. The city council.
But the point is that even if you were outside the park, if there was a rule that was implemented that says you have to stop horse-drawn carriages at midnight. I mean, you have this section F here, subdivision F or subsection F that kind of cuts against any argument that you can't reduce my time.
Well, I hear you, but I think that the intent of that is for the city that in adopting this rule, there's no findings, there's no discussion about cutting the hours of the horses. There's no evidence of it, and there's no consideration of it. So I don't think that would allow them to do that.
Thank you, Counsel. You have a minute of rebuttal, okay? Let's turn to Ms. Gustafson.
Yes, Your Honor. Ingrid Gustafson, appearing on behalf of the city, and may it please the court. In dismissing this Article 78 proceeding, the Supreme Court correctly recognized that petitioners' contentions here really fundamentally misconstrue the scope of a very specific authorizing provision.
Counsel, I'm sorry, this is Justice Moulton, sorry to interrupt you, but with respect to the horse's health, didn't the ASPCA weigh in on this issue?
It absolutely did, Your Honor. I mean, our fundamental point is that this is a traffic rule, which absolutely has a rational basis in regulating traffic and preventing conflict with horse carriages. But to the extent it's not a rule about horse health. But in any event, yes, the American Society for the Prevention Against Cruelty Against Animals supported this rule and said that it would be better for horses to be in the park instead of immediately adjacent to traffic.
Your opponent also said that there, I'm sorry to interrupt you again, but on a separate topic, your opponent also said that there wasn't anything in the record concerning collisions between automobiles and horse carriages. Is that correct?
That is inaccurate, Your Honor. There are actually multiple places in the record where that appears. The letter from the city council, the 4 city council members whose districts surround the park submitted a letter in support, and they mentioned 2 recent crashes as a basis for their support. And one of those, I believe, was on 59th Street, was on Central Park South. The petitioners themselves submitted a FOIL response from the Department of Mental Health and Hygiene, which listed 7 different crashes in the preceding 3 years. That's at page 107 of the record, and that included 3 on 59th Street, which is Central Park South, and also in our opposition that was submitted in Supreme Court at page 251 of the record. The city also mentioned a few recent crashes. Crashes between horse carriages and vehicular traffic and other types, and pedestrians and bicycle traffic are not uncommon. And it's certainly fully rational whether or not there had been one. There was a specific crash while the horses were standing in line, it was fully rational for the Department of Transportation to say it will reduce the chance of conflict if we move the boarding areas from where they are right now along 59th Street, in taking up a lane of traffic immediately adjacent to active lanes of traffic. And we now move them inside the park where public vehicular traffic is now prohibited to reduce the chances of conflict. That is absolutely rational. I would like to address the boarding space issue. Justice Renwick, you're actually absolutely correct. Prior to this rule, the only signed boarding spaces, which were along against Central Park South and 59th Street, provided 1,010 feet of boarding space. And so when in adopting this rule, the Department of Transportation sought to match that space, and it put 1,050 feet of space within the park. Petitioners are really talking about lining up sort of outside of boarding zones, which really isn't a matter addressed by this rule at all. And I would like to emphasize that there is no evidence. Petitioner's argument on this front is really is based in an assertion that this rule would prevent them from every single licensed horse carriage operator from all being in the boarding space at the exact same time. But they have never claimed that that is something that they do as a usual course, or there's no evidence in the record that there would in fact be insufficient space under usual operations.
Thank you. And this rule was supported by the Parks Department, the City Council that you already mentioned, the ASPCA that you already mentioned, DOHMH. So all of those agencies, and there was a hearing here. Is that right?
Yes, absolutely correct, Your Honor.
Okay, thank you.
Lengthy hearing. Thank you.
Thank you. Let's go back to Mr. Sheldon.
Just 3 quick points. Is when the ASPCA, which is committed to eliminating the carriage horses from operating, commented on the proposed rule, the downhill zone was not in existence. The downhill zone came when the rule was finalized after the input. So no agency with any knowledge about the health and well-being of horses has ever weighed in to that lining them up in a dangerous position is good for them. That was a fundamental error, and our horses are suffering every day by having to line up there. Regarding the amount of linear footage, our industry is being harassed every day because there's not enough space in the park for them to line up in the zones that have been established. Why the Department of Transportation pig-headedly refuses to add additional footage so that our horses can line up without getting ticketed, I don't know. They never said, but it's wrong. And before this rule, we could line up our horses all throughout New York City, not just where they had a little painted white line. So for the Department of Transportation to say, well, our white line before and after is about the same, so don't complain, is really a gross misstatement of the industry. They did not set aside enough spaces for our horses. They refused to do it, and they should get no deference whatsoever for putting horses in a dangerous position day after day after day.
Thank you. Thank you, Mr. Sheldon. Thanks to both of you.
Thank you.
LePatner Project versus 320 West 115th Street.
Thank you, Your Honor. May it please the court, Jason Stern for appellants. Your Honors, this is a classic account stated claim. My clients rendered services over the period of more than 10 months, and in connection therewith rendered 17 detailed, specific, timely invoices to the defendants, and the defendants did not render one objection, not one. So over that—
Counsel, weren't there any disputed fees? Are all of these fees undisputed?
Wholly undisputed during the time of issuance. Every dispute that's been raised is after the fact, not one word during the course of the services and not one objection during the rendition of the invoices, only after the fact. And this court has held, and it's well settled, that silence will be construed as acquiescence in the justness of the invoices. And that's precisely what's happened here. We rendered invoices, Defendants failed to object.
What about the additional services? Didn't they object and say that they didn't have any additional services? They didn't ask for additional services?
Respectfully, Your Honor, they did not. And again, the record's clear. From March to December of 2017, nothing.
What about the way you applied the payments, the partial payments? I mean, they had paid money, and there were I think they paid $200,000 or something, 100, and you applied it in different ways to different.
Yes, Your Honor, we applied it to the. That's correct. I'm sorry to interrupt.
No. And so some of those were undisputed, but weren't some of those disputed fees?
That's never been part of the record, never raised by the defendants. What happened, Your Honor, is we rendered the 17 invoices. They totaled about $640,000. Those invoices rendered through December, not one word from the defendants. A few weeks later, they paid $200,000, which we applied to the oldest of those invoices, leaving about $440,000. And then a few weeks after that, they concoct their explanation. Oh, we forgot to mention, your bills are too large, you rendered poor services, we're not happy. But those are the classic Monday morning quarterbacking cases.
Counsel, this is Justice Moulton, sorry to interrupt you, but with respect to the $175,000 bonus anyway, wasn't that timely objected to in writing via the January 15th email? Was it an email? I forget, but it was in writing. I mean, you concede that that was timely, would you not?
I would concede that was timely if only the $175,000 was based on an invoice. I concede that, but that $175,000 was set forth in a separate agreement, a March 2017 agreement, where they agreed to make that payment at the conclusion of services. So that invoice is a little different. I agree with Your Honor, but I also think it deserves a different treatment because of the additional agreement with respect to that fee only. I'd also like to point out that in our contracts, the two agreements at issue, we specifically say, my clients specifically say that you are to review each invoice upon receipt and notify us immediately of any error or discrepancy. You've got the right to object to our invoices within 30 days. And in the event you fail to object to an invoice within said time period, the invoice shall be deemed admitted. So both as a matter of law, which this court has held time and time again, Morrison Cone, Spectra, M&R, Parker Chapin, cases are legion. In addition to the legal point, the common law point about account stated, the contracts themselves require the defendants to render timely objections, which they failed to do. I'd like to make another point. The essence of the trial court's decision was about the partial payment that Justice Renwick mentioned. But the trial court, I think, misconstrued the law about partial payments. The trial court said, oh, they rendered a partial payment. That shows that they weren't happy with the services. But that is the opposite of the clear and settled law in this court. That's according to Morrison and Cone Waters, Shea and Gould v. Burr.
You might be right about that, counsel. Sorry to interrupt you again, but let's talk about the legal fees for a second, because of course they do have legal malpractice counterclaims, which they say are inextricably intertwined with the bills submitted for legal services. So what about that? Do those bills stand on a different footing than the ones for the construction work?
Respectfully, Justice Moulton, they do not. They're still account stated. Even if there were some basis for their malpractice claim, number one, they needed to come forward, lay bare their proof, which they failed to do. But number two, they're again after the fact. And in all the cases we're looking at, most of them involve legal bills. Those cases also have defendants coming back months later after successful completion of work and saying, oh, gotcha, you committed malpractice. Never before raised. There are no different standing, Your Honor.
Thank you.
Thank you.
Mr. Mullaney?
Yes, thank you, Your Honor. Good afternoon. Tom Mullaney for all the respondents. First of all, Mr. Stern is incorrect. There were objections that were made, both oral and written. And although,
but with oral objections, don't you have to be a little bit more specific than to say, oh, we made oral objections, we raised this? I mean, don't you have to say when you did it, how you did it, who did it, to whom?
Yes, Your Honor. And the cases that Your Honor is probably thinking of are involve larger law firms, Morrison Cohen, Shea and Gould, Paul Weiss. Here, Mr. Kirschenbaum says he discussed them with Mr. LePatner. He discussed the size of the bills. His January 15 written objection, which is timely, also refers to conversations they had about the dysfunctionality of the team, how it's driving the costs up, and so forth. I would also note that Mr. LePatner does not, under oath, anywhere in the record, say, I didn't have those conversations with Mr. Kirschenbaum.
Well, but it's your burden, though, counsel, to establish when the objections took place, what was said, et cetera. And it seems to me, I kind of agree with Justice Kapnick, that the statements that are in the record are very general and not specific to time or place or content.
Yes, Your Honor, and there's no dispute that they are not the most specific. They're not verbatim, but I think at this juncture, we just need to, and some of the case law supports this, show a basis to inquire into whether those conversations happened, that there is reason to believe that there was a dispute that was raised orally or contemporaneously with Mr. LePatner. I believe there is one, and there is reason. It is because there are both the general notions that there were conversations that were had. There were contemporaneous in the January 15 email reference to those specific conversations where specific things were discussed, like you and, so Your Honor, looking a little quizzically, if you look at the January 15th email, Mr. Kirschenbaum says, essentially, we discussed why you and Chuck Boyles didn't speak to each other and the dysfunctionality of the team in general and how that is causing added time and costs to go up. That's a fair reading of that is the bills are too high, and that's because you guys aren't doing what you should be doing. You're not talking to each other.
Well, Mr. Mullaney, can I ask you another question? Do the legal fees bills fall into a separate category because of the fact that there is a legal malpractice defense that was raised in this complaint or in this answer?
Yes, I think they do, Your Honor. I mean, I don't think there's really much of a dispute that the malpractice that's alleged, and there was never even a motion to dismiss made against those claims, never mind our burden to show that they ought to go forward. There's nothing. I mean, they are going forward. They're plainly intertwined in time. The invoices that are submitted are refer to the issues that have been raised in the malpractice claim, particularly the $1 million default fee from Avant. The cases that are referred to in Appellant's brief talk about malpractice having occurred before the bills being rendered. That's not the case here. I think as a subject matter, it is clear that at least we've properly raised the issue of whether there is a ethical defaults, really is accurate to say, in having LePatner Project Solutions and LePatner, the law firm, double billing. The bills themselves reflect double billing from Mr. LePatner, where he is issuing from his law firm bills that for work that's on its face is for construction services that should be covered under the flat fee and aren't. He's billing a non-attorney through his law firm. He has made himself a fact witness, a crucial fact witness in 2 litigations. He doesn't raise to the client that, by the way, if I do this, if I have LePatner Project Solutions as the construction manager, I won't be able to litigate any case for you concerning that because I'll be called as a witness. Doesn't even raise that. And if you look at all of the fees all together for a building that's got 5 units in it, it's not a skyscraper, everything added up would be nearly $1 million in fees. And that's astonishing. Not a complaint was filed, not a deposition was taken, nothing. There was construction work done, but the legal fees. One last point, if I could, Your Honor, if I have a little time. The complaint and the account standard claim and the complaint both seek separate numbers from the motion for summary judgment on an account stated. That's $440,000. The account stated claim in the complaint is for $550,000, and the complaint itself seeks $660,000. That alone is an issue that precludes summary judgment here, where we should have depositions, and most of the case law says where there are these issues of attorney conduct, there should be a hearing. I see Your Honor is yawning, so that's a good point for me to wrap up.
And sometimes it's just a natural thing the body does.
Yeah, please don't take that personally.
No,
okay. Back to you, Mr. Stern.
Thank you, Your Honor. I'll be brief. 3 points. First, all of Mr. Mulaney's points are interesting, but they're not part of the record. Not one objection made over all the course of those invoices. Where's their allegations of malpractice? Where's the dispute about the bill? Oh, you should have charged me this. You charged me that. They have 70 pages of invoices, not word one. That's first point. Second point, it's summary judgment. We've put in our evidence. Where's theirs? They've got nothing. There's no support. The obligation was theirs to lay bare their proof. They failed to do that. And finally, with respect to these specious malpractice claims for which they have no evidence, they have an alleged but-for causation, very difficult to prove. They haven't even tried to prove it. They're just kind of throwing it to the court to say, oh, chew on this. They'll have their opportunity to pursue those claims. Those claims aren't being dismissed or disputed here. This is just about our account stated claim. Thank you.
Thank you both. People versus Terrell Myers.
Good afternoon. May it please the court. Anjali Padmanathan on behalf of Mr. Myers. In this case, Your Honor, the trial court committed reversible error in failing to give the jury the circumstantial evidence charge, which counsel requested at the charge conference. The prosecution's case in chief relied wholly on an inference that the bag that Undercover Officer 308 and Detective Clark saw Mr. Myers carrying into the park.
Can I ask you, wasn't there, I mean, my understanding, and correct me if I'm wrong, is that the circumstantial evidence charge would only be appropriate if the case was based completely on circumstantial evidence. And wasn't there at least one officer who saw the defendant walk into the park carrying this black plastic bag and then placing it behind the bench where he then sat? It wasn't that direct evidence.
Your Honor, there's direct evidence of that. Yes, Detective Clark and Undercover Officer 308 saw Mr. Myers carry a generic black plastic bag into the park. But that's it. They were not present at the scene when Detective Hiller recovered a black plastic bag containing contraband somewhere in the park. And in fact, when—
Well, it wasn't somewhere in the park though, counsel. Wasn't it underneath the bench? And it was differentiated from the other plastic bags underneath the bench in that it was less weatherized. I don't know if that's a word, but you know what I mean. In other words, it was a fresher plastic bag. And so
it didn't have garbage in it.
Actually, it was not found underneath the bench.
It was not.
The bag that was found with the contraband was somewhere in the bushes in the park. And I'm glad you brought that up, Your Honor, because actually the record is very unclear where these detectives even found the bag. Detective Hiller said he found the bag to the left of a photograph. I've submitted to Your Honors all of the exhibits that are relevant in this case. And in People's Exhibit number 8, if you look at that exhibit, it's a view of the park benches. And Detective Hiller, who said he found the bag, said that the bag was located to the left of that image. Whereas Detective Ayala, who was helping with the arrest, says the bag was found to the right of that image. When you look at that, we're talking about 20 yards or so away from each other. And the bag was not found underneath Mr. Myers' bench where he was found arrested, whereas the undercover officer testified that the black plastic bag that was underneath Mr. Myers' feet, that was underneath the bench, which you can see in People's Exhibit 2, which I've submitted to the court, there's a black generic plastic bag under his feet. And she said that looked like the bag Mr. Myers carried into the park. The crucial fact here is that the prosecution's case of constructive possession relies entirely on this inference that what the undercover officer saw and what Detective Clark saw of Mr. Myers carrying a generic bag into the park was the bag that Detective Hiller recovered later. And I'll just point Your Honors to the record where Detective Clark actually says he's asked, during trial, he's asked whether he could say anything about whether the bag that was recovered was the bag he saw Mr. Myers carrying into the park. And he says, I can't even say what bag, if any bag, was recovered at the scene because they weren't there when a bag was recovered. Similarly, the undercover officer only identified this wholly different bag that was underneath the bench. Now, when it comes to circumstantial evidence, the circumstantial evidence charge is required even when there is direct evidence if the prosecution's case is entirely based on this inferential link. So what we have is direct evidence that Mr. Myers carried a bag into the park, and we have direct evidence that Detective Hiller recovered a bag. We don't have anything connecting those two bags together. It requires the jury, requires all of us to draw an inferential link. And that's exactly when the circumstantial evidence charge is required. I point your honors to the CJI instructions itself with the the analogy of the wet clothing and the wet umbrella that a person in a subway sees, right? So a person is in a subway, she's a witness. She says, I see a bunch of people who have wet clothes and wet umbrellas. That's direct evidence. But whether or not it's raining outside is based on circumstantial evidence. And that's exactly what we have here. We have direct facts that are in the record that are based on direct evidence, but they don't make Mr. Myers guilty of criminal possession of this weapon unless—
This is Judge Owen, but these deficiencies are that you're pointing out to us, this was all played out in front of the jury, correct? Or am I missing something? The trial counsel didn't make these arguments before the jury?
Your Honor, trial counsel made these arguments, certainly, but the jury was entitled to hear the circumstantial evidence charge. The circumstantial evidence charge itself is very specific. It asks the jury to specifically look at any inference. And I can quote, it says, the jury must draw an inference of guilt. It must be the only one that's fairly and reasonably drawn from the facts. And not only that, the evidence then has to be excluding beyond a reasonable doubt every reasonable hypothesis of innocence. And again, I submit, Your Honors, if you look at the images, there are at least 3 black plastic bags surrounding where Mr. Myers was sitting, where this gun was purportedly found. They should have had to draw every reasonable hypothesis of innocence.
Counsel, you're arguing about circumstantial evidence, unless I thought that there was testimony from the other undercovers that they saw him with a black plastic bag or a plastic bag.
They saw him with a black plastic bag, certainly. They didn't see him with the bag. They didn't see where Detective Hiller recovered the bag containing contraband. That's what's crucial here. This is not some self-identifying item. This black generic plastic bag is something that is ubiquitous in New York, right? It's ubiquitous in this park. There's 3 different bags just in the images the prosecution submitted to the jury. So the issue here is that no one actually knows whether the bag Detective Hiller recovered is the bag that Mr. Myers carried into the park. And the reason this is so important, Your Honors, is because there's nothing connecting Mr. Myers to the contraband within that bag. There's no fingerprint evidence or DNA evidence connecting him to this gun. There's no eyewitness testimony that he had possession of any of these things before. This simply, everything about the prosecution's case here was based on inferences upon inferences. And so that is exactly the type of case where the jury should hear the circumstantial evidence charge so that they know that they have to review every inference and make sure that they believe in it beyond a reasonable doubt. And Your Honors, if I just have a few moments, I would like to also address the excessive sentence claim that I've raised in the briefs.
I'll give you 30 seconds because you also have rebuttal.
Certainly, Your Honor. So in this case, Mr. Myers was sentenced to 5 years in prison and 5 years in post-release supervision. I submit that that sentence is excessive based on his circumstances. The minimum sentence is appropriate in this case where he would face 3.5 years in prison with 2.5 years of post-release supervision. This is his first felony conviction, and actually after 2019, this is the only conviction in his criminal record. At the time of this offense, he had several marijuana-related contacts with the system, only one of which resulted in—
Weren't there several arrests after this particular case, and were those all just marijuana arrests, or were those for anything other than that?
I believe there were other arrests before or after this case began, Your Honor. They were all marijuana-related offenses. And
what was the minimum in this case? Was 3.5 or 4?
3.5, Your Honor.
Okay, thank you.
Yeah.
But didn't the sentencing judge at sentencing made a remark that with respect to the conviction for the weapons possession, that he still, the court really honed in or zeroed in on the weapons possession charge when he decided to impose a 5-year sentence? Or am I reading the wrong sentence minutes?
John, the minimum sentence permissible for the weapon possession charge is 3.5 years in prison. Nothing about the fact of Mr. Myers' life or his character justify anything more than the minimum in this case.
This was a trial, right? So this was a trial. So this was not a negotiated plea where he pled down from something. This was what he was convicted of, and that is the minimum for this conviction.
3.5 years in prison is the minimum, and 2.5 with post-release supervision.
It seemed like the judge may have, during the sentencing, well, maybe it wasn't, the prosecutor indicated that the defendant did not take this case seriously because there were 6 arrests after this trial. I guess that's what that was pointed out to the court by the prosecutor.
Your Honor, obviously, Mr. Myers took this case seriously. Obviously, he took these allegations to trial. He's maintained his innocence the entire time that he did not knowingly possess this weapon. At the end of the day, the sentencing court potentially overlooked the strength of the support he has from his community. I submit to look back at the community letters written by his family members, the elderly neighbors that he takes care of, the people that consider him a mentor and a support system. And also look at what he was doing during the course of this prosecution. This was, he had finished high school, he had attempted at higher education, he had achieved obtaining a job in which his employer provided a letter of support. He had voluntarily attended the Next Steps program and entertained 72 classes voluntarily in order to better himself. And on top of that, he was volunteering at a youth center for kids to teach them basketball and keep them off the streets. I mean, if these facts don't call for the minimum, I'm not sure what do.
Thank you. You have 2 minutes rebuttal. I've given you over the 30 seconds. Okay. Mr. Goldfein.
Good afternoon, Your Honors, and may it please the court, Samuel Goldfein for the people. I'd like to start with just highlighting briefly the direct evidence that supports defendant's conviction here. Defendant sold fake narcotics to an undercover officer. He then was observed by 3 police officers carrying, or 2 saw him carrying the bag, but 3 saw him walk into the park. He sat down on a bench. An officer
I'm confused. The 3 who saw it, just correct me. The 3 who saw him walk into the park, were they the same 2 that observed him carrying the bag? So 2 observed him carry the bag, then another 3 saw him walk into the park. Is that what you?
No, the first, Your Honor. So 3 saw him walk into the park. 2 of those saw him carry the bag. 1 of them saw him place that bag directly behind the bench that he was seated on. All of the officers testify that defendant. Sorry.
So, yeah. So are you saying that the person who saw him put the bag under the seat also was one of the initial people who saw him holding the bag before he entered the park?
Yes, Your Honor. It wasn't under the seat. It was behind so the bench is
behind the seat,
there's like an embankment wall. Right. So that's Detective Clark. So he sees him place the bag in that location. He radios the field team. The team moves in. Every officer testifies that defendant doesn't move from that location until he's arrested. He doesn't get up. Nobody approaches him. Nothing of the sort. And then while defendant then throws himself on the ground, he's claiming that he's injured. And Hiller searches the area. He finds the bag directly behind the bench that defendant is seated on. There's compelling, like every officer testifies to that. Ayala and Rosado are both there they're struggling with defendant, trying to put him in handcuffs. And they say that Hiller was right there. He pointed out the gun to them. He says it's a hot lunch. I'm sorry, have I disconnected?
No.
I thought it was a technical glitch. So there's evidence.
Let me ask you another question.
Yes.
Does Detective Clark anyway, does he ever lose sight? Is the defendant ever out of his sight? Does he ever? No.
There's no testimony to that, Your Honor. No, I mean, he sits down on the bench. The whole team watches it. Clark testifies that he observes the team move in and arrest defendant. They confirm that he has the right guy and they leave before they discuss the bag. Clark never sees the bag recovered, but the inference that's being drawn here is that a bag placed in a location didn't grow legs and walk off. I mean, it's found directly behind.
Okay. How did he not see the bag recovered if he never lost sight of the defendant with the bag, bringing the bag in, placing the bag?
So he loses sight of the bag, I suppose, when defendant places the bag behind the bench. Then Clark can no longer see the bag. Clark and Recover confirm that the team has apprehended the correct individuals, defendant Alonzo, Georgia, and Thomas, and then they leave. So they don't stick around to see the bag recovered and to confirm that it's the identical bag. But we have all this direct evidence that establishes that the bag that was placed directly behind defendant is the bag that he carried into the park. Beyond that, there is other circumstantial evidence or more circumstantial evidence that establishes this bag belonged to defendant. First and foremost, it's implausible that someone would abandon a gun and drugs in a park and walk away from it, and that defendant just happened in that location to deposit his own bag nearby.
Well, there were no drugs. Is that right?
Well, there was imitation controlled substances, Your Honor, which again is also compelling evidence that this bag belonged to defendant. These substances appeared identical to the substance that defendant had sold to the undercover officer earlier that day. Also, defendant feigns an injury, right? The cops know that he can walk around. They've observed him going up and down stairs. They saw him walking to the park, but he throws himself on the ground. That's circumstantial evidence of consciousness of guilt. But because there is ample direct evidence, he was seen carrying the bag into the park. He was seen placing the bag in a location. The bag was recovered from that location. There were substances in the bag that were identical to what defendant was selling. There's all this evidence that establishes that this bag belonged to defendant. So I think there's no question here that no circumstantial evidence charge was required because there's all this direct evidence. And even if a circumstantial evidence charge was required, it's harmless. There's no complex chain of reasoning. There's no inferences to be drawn. It's simply that a bag recovered from a location where it was seen dropped is the same bag. Also, Hiller did look at those other bags. Counsel made point of there's bags in People's Exhibit 2. Look at those other bags. There's testimony. I looked through the bags. There were other bags in the area, but they were weatherized, as Your Honor put it. They weren't brand new. And most importantly, they didn't have things inside of them, right? The testimony is that defendant's bag that he carries into the park has something inside it. So if there are no further questions about the circumstantial evidence, I would briefly, sorry.
Oh, you're moving on. I thought you were going to end. Go ahead.
No, I would briefly just go to the excessive sentence, just to touch on it. So yeah, yes, this is defendant's first felony conviction, but I would just note that the circumstances of his weapon possession are a bit more extreme than the ordinary. It's not just possessing a weapon. He brought this weapon into a park, and he's brought it into a park with the intent to use it unlawfully to defend his drug business. He's working with several other individuals.
He intended to use it. I didn't hear the word.
Oh, unlawfully against another person, Your Honor. That's one of the crimes he was convicted of weapon possession.
Well, when a person is in possession of a weapon without a license, they intend to use it unlawfully against somebody. They're not going to just start shooting leaves on trees. I mean, isn't that the case?
I absolutely agree with Your Honor, but I think this is a little bit different because it's not he just has this gun on him. He's using it with his drug business, right? The gun is in the bag with the imitation drugs that he's selling. He's working with Georgia, working as a steer, right? He brings UC 308 into the building. He has Thomas working as a lookout. I mean, he's using this gun to defend. Defendant is holding the stash and defending.
That's not what he's charged with, is he? He's charged with, what is the charge exactly?
So there's 2 counts of second-degree weapon possession. One is for intent to use unlawfully. One was for possession outside the home or place of business. And then there's a weapon possession for a defaced firearm for criminal purpose.
So all of those are just, all go to the weapon.
Absolutely. Well, he's also convicted for the imitation controlled substances, but that was a misdemeanor charge. But I think the totality of the
someone has them, everyone would mute themselves if they are not.
I think she could move. It would be a major inconvenience to her to have to.
Yeah, they're too involved in whatever they're involved in. They can't hear. I'm sorry, Mr. Goldfein.
No problem, Your Honor. So just the totality of the circumstances established that he is using this gun as part of his drug business. It was in the bag with the drugs, and these 2 other people as part of his drug business. So I think that it justifies a sentence above the bare minimum. Again, defendant faced up to 15 years. He got 5, just above the 3.5 minimum.
Did he have any other felony convictions?
No other felony convictions, Your Honor.
All of his other convictions marijuana based or something like that?
At the time the sentence was imposed, he'd had several pending convictions. I don't think it was clear. As it turns out, he only has this one other conviction, I believe, for marijuana possession. At the end.
So under those circumstances, under the circumstances of his family and everything else, and the fact that a gun is a gun is a gun, you may not. I mean, he was involved. You were able to see the fake drugs here, but no one has an illegal weapon that is not meant to be used against someone else or for protection or whatever else it is. I'm just
absolutely, Your Honor. I mean, I agree with you.
The fact that he got 1.5 years over the minimum here, given everything else. Thank you.
And thank you, Your Honor.
Pathamathan?
Your Honor, I want to clarify the record regarding this narcotic sale at the beginning of Mr. Myers' case. In fact, the circumstances here are not what the prosecution are making them out to be. Mr. Myers was not some sort of ringleader for this group of 3. What happened was that the undercover officer was repeatedly targeting a 16-year-old named Alonzo Georgia to sell her drugs, to sell her crack cocaine. She went up to him initially when Mr. Myers was not even at the scene. She went up to him with Mr.
Counsel, but the bottom line is there was a drug transaction, right? There was a sale going. There was a buy and bust going on, correct?
Yes, but Mr. Myers was not present when the imitation drugs exchanged hands. So what the prosecution is making it out to seem like Mr. Myers was the ringleader of this group, he wasn't even there when the drugs were sold, the fake drugs were sold to the undercover. What we have is a young man who took $10 from an undercover officer and never returned, never exchanged anything to her. That's not what
No,
the
but counsel, the way the concern I have, or the problem I has, is that it was just not mere possession that he has. He may not have been there at the moment of the sale of the transaction itself, but he was part of a group that was this was the business that was going on there. I mean, right? I mean, he didn't happen to just happenstance to be there, right? Correct?
That's the prosecution's theory of their case, but they don't actually submit any evidence of that besides this one interaction between Mr. Georgia and the undercover officer. There is no evidence that suggests that there was some sort of larger business going on.
Should Mr. Goldfein be charged since he had Mr. Goldfein? I'm sorry. Since this Mr. Myers, it sounds like what Mr. Goldfein, I guess maybe that's why I mentioned your name, Mr. Goldfein. It sounds like what Mr. Goldfein is saying is that because he had this extra business or whatever he was doing, he deserved the sentence he received. But it sounds like he's being held to the same level that one who had real drugs would have been held, an enhanced sentence. The drugs aren't real here. I mean, this is all real here. The drugs are not real. This person obviously doesn't have the ability, I guess we can assume, or else he would have real drugs instead of fake ones. And he's getting an enhanced sentence for a fake business.
Yes, and he's also being made out to be running a fake business when there's no evidence of that. In fact, if you look at the record, both times, the only time the undercover officer interacts with Mr. Myers and the time before when she interacted with Mr. Georgia, they both told her to go and talk to their boy, whoever this person is. Obviously, these young men were not running their own business. There's no evidence of that. And what we have here is two teenage boys and one over the teenage age, Mr. Myers, all caught up in one incident, one buy and bust event. And the teenagers can't be prosecuted the way Mr. Myers is. So he's being sort of put on the blame of everything that happened here, when in fact, Alonzo Georgia is the one who conducted this exchange with the undercover. So I take issue with the way Mr. Myers is being characterized as some sort of drug leader that was selling fake drugs in order to protect, and then having a gun to protect himself and his purported business from drug addicts. None of that is in the record.
Thank you, counsel.
Your Honor, if I may just add one last thing.
It really has to be 30 seconds. I've given you quite a lot of time.
Certainly, Your Honor, but even less than that. I just want to point out that the prosecutor is still relying on inferences to connect this gun to Mr. Myers. Even if he used the word inference in himself. He says it's implausible. These are all suggestions of inference. If the jury has to rely on an inference to the crucial aspect of criminal possession of a criminal possession of a weapon, and it's a constructive possession charge, the circumstantial evidence charge is required. Only in the exceptional cases, the Court of Appeals said that the circumstantial evidence charge falls under harmless error review. This is clearly not an exceptional case. Therefore, the gun charges have to be reversed and a new trial ordered on at least those charges. Thank you so much, Your Honor. I appreciate the extra time.
Thank you. Thank you both. Thank you, Mr. Goldfein. 14th Street Medical versus Epstein.
Thank you, Your Honor. I'm going to start by focusing on why both of plaintiff's claims actually should have been dismissed on summary judgment. And starting with its second claim for breach of the contractual non-solicit. The non-solicit provision is clear that it only applies for a period after she left the corporation. There's absolutely zero evidence in the record of any post-employment solicitation by her. What is in the record is Dr. Epstein's affidavit and testimony or affidavits from the 4 employees identified by the plaintiff sworn that no such solicitation have occurred. In fact, Mr. Feldman, the practice administrator for 14th Street, when asked by me what basis he had for believing that Dr. Epstein had solicited staff members to resign after she left 14th Street, said that she didn't do it after, she did it while. Unfortunately for him, the contract provision didn't preclude her from soliciting employees during her employment. It only prohibited her from soliciting employees after she left the employee. And notwithstanding that, the trial court held, as in the decision, that the reason that it was denying our motion to dismiss non-solicit claim is because the date of Dr. Epstein's resignation is unclear. That is just not the case. There's ample testimony from Mr. Feldman, from Dr. Epstein, from Ms. Fontanez, who overheard the firing over that Friday, February 9th, 2018 was the date that she stopped being employed by 14th Street. We can fight over whether that happened because it was a termination or a resignation, but there is no dispute that February 9th was that date. And we look at the text message that the
excuse me, counsel, wasn't there a email that defendant sent on February 10th stating that her resignation date is effective 2/7/18? So doesn't that conflict with the 2/19/18 date that you're making reference to?
You said 2/19. I think you made 2/9. Right?
2/9. On February 10th, I thought, the defendant sent an email stating that her resignation date is effective on February 7th. You said it's February 9th. So during that time, a lot of things happened. How is that clear that it's not the 7th or the 9th?
Look, because these are words sent by Dr. Epstein clearly after she had become a former employee. However it was that she ended up typing out February 7th rather than February 9th. There's no dispute that on Wednesday, February 7th, she remained employed by the company. She wasn't fired that day. She didn't quit that day. Same with February 8th. February 9th in the morning, everything blew up. And if you look at the text relied upon by the court at page 153 of the record, it's a text from Dr. Epstein to one of the women involved, actually Perez, sent at 8:05 in the morning, where Dr. Epstein texts her, "They crazy, we should all quit at once." The text saying we should all quit at once 2 days after she had already quit. I submit that there is not that, regardless of what Dr. Epstein wrote in her email the next day, when she was clearly at that point a former employee, there isn't any actual evidence of a post-termination solicitation or post-resignation solicitation actually having taken place. There's just an email that likely misstates what date her employment ended, but they have to prove that there's actually an actual solicitation by her that occurred after her employment ended. Mr. Feldman does not dispute that her employment ended on February 9th, and there is no evidence in the record that there was a solicitation that occurred after her employment ended. Turning to, and for that reason, there's just the summary judgment should have warranted dismissal of the claim based on the non-solicit for complete lack of evidence of a breach. Turning to the first claim for breach of contract and breach of the notice provision, that claim actually should have been dismissed on summary judgment because of a complete lack of any recoverable damages having been established by the plaintiff. In response to our interrogatories, plaintiff identified a whole slew of categories of possible damages. The primary one in terms of magnitude was lost profits. Unfortunately for the plaintiff, New York law is very clear that lost profits are not recoverable on a breach of contract claim unless the contract language demonstrates that the party contemplated that. This contract is absent of any evidence the parties contemplated lost profits. Moreover, the actual evidence of lost profit, there's no actual evidence of lost profits. That's not completely speculative. Mr. Feldman couldn't identify any who didn't come in during the 90 days following her alleged resignation, who would have come in but for her breaching the notice provision. He couldn't identify any tests that he said would have been run, therefore generating income for the practice during those 90 days. The practice that had only room for 2 doctors to work at the same time, and he couldn't identify of the 90 days following her termination or resignation when the company actually had fewer than 2 doctors working. They hired 3 new doctors in the 2 months following her departure. They couldn't identify how much of her production had been replaced by those doctors. They produced a summary of receipts and bank statements that don't reveal when Dr. Epstein provided the various services that led to payments coming in, given that payments could have come in 30 days, 60 days, 90 days. There's just no basis on which a court could ever conclude that 14th Street would have made more money during the 90 days following February 9th had Dr. Epstein given 90 days notice.
Thank you, Counsel. Okay, I'm sorry, go ahead.
No, it's okay. It's not necessary. Thanks.
Okay. Mr. Kuttner?
Yes, good afternoon, Your Honors. May it please the court. I'm going to first address what my adversary said. Regarding the issue of the non-solicitation provision, as the trial court recognized, the emails and the text messages create some uncertainty as to the temporal relationship between when the individual, Dr. Epstein, resigned. For example, on the morning of February 9th, 2018, at 8:05.42 a.m., she said to one of her coworkers, they crazy, we should all resign at once. She testified at her deposition very unclearly as to who made the decision first. It's clear these were all four people who were junior to her. They reported to her. They were staff workers. It's absolutely clear that they followed her out the door. What counsel did is he's relying on one isolated statement from Mr. Feldman at his deposition. And he's also mentioning on the damages issue. And I think this is very important. First, the trial court said they didn't award 14th Street Medical PC $500,000 or more of damages. They said they're going to have an inquest and prove their damages. But in the meantime, what counsel is trying to do, and he argued this previously to no avail, is he's trying to argue that we're required to prove damages at this juncture with absolute certainty. For example, he claims that we had a claim on the under the faithless servant doctrine. And that claim was not even asserted. He says that Mr. Feldman was unable to identify even one patient, leaving aside HIPAA issues about identifying patients. Mr. Feldman testified, and it's in the record, I can provide you with a whole list of patients. Counsel said, no, too late, you didn't do it. I don't want to hear about it, okay? So that's not a true argument. It's clear that the damages are multiple categories. There was hiring expenses, there were advertising expenses, training expenses, social media expenses. And on top of that, Mr. Feldman produced bank statements, and he also produced two different types of analysis as to the business losses, which admittedly he will have to prove at the trial. One thing that counsel did not mention in his presentation, which is also important, when a doctor leaves, there's the reason the 90-day notice provision in the agreement, which it seems now they're conceding that Dr. Epstein resigned and was not terminated. But the 90-day notice provision is there to assure not only the smooth clinical workings of the corporation, but so that they can hire somebody, the employer can hire someone, bring someone in who can, in fact, take over for Dr. Epstein.
Counsel, moving away from damages, you've done a very good job laying out what your alleged damages are, but what about the fact that the defendant is also saying a breach of paragraph 5.2, which is the one that gives all the doctors their independent judgment about what they should do? Was there a prior breach by your client?
No,
you, of course, to have a breach of contract claim against the defendant, you've also got to you have to have lived up to your side of the contract, and they're alleging you didn't.
Absolutely, Justice Moulton. And what happened here is that after an extensive record, you see all the testimony, all the depositions, the only document that was ever produced by the appellant was a single email dated February 8th, 2018, the day before the resignation, that said, it was not, I apologize, not an email, a text message where Mr. Feldman said, we're losing money, that sort of thing. He said because there haven't been a full amount of tests. There's not a single document that says that Dr. Epstein was forced to perform tests on anyone that were not.
What about the other doctor's testimony that they felt similar pressure? So Dr. Hanif gave some testimony about that, for example.
Dr. Hanif was a medical doctor who was, my understanding is she either terminated or was terminated or resigned in a very disgruntled manner previously. And regardless of whether or not, Justice Moulton, regardless of whether or not she felt pressure, her pressure is not the same as Dr. Epstein. Dr. Epstein also said during her deposition that she maintained contemporaneous notes of everything that had been done to her, all her objections. Lo and behold, doesn't produce any contemporaneous notes that say anything. And also, she applied to be the medical director of this company. So, and Dr. Epstein also said that she didn't apply for a new position until she was terminated. Well, we have evidence in the record that she, on February 8th, she had already secured, the day before her resignation, she had already secured an interview with her employer, SN Medical, who I believe is her present employer. And not only that, she claims that on her counterclaims, she has damages, but she admits that instead of starting her new job right away, she either went to Brazil for a family vacation or a family emergency, depending on which version of the story she said. So she took in her words, a vacay for 3 months before she started. So if anyone here doesn't have damages, it's not 14th Street Medical, it's Dr. Epstein. And
thank you.
Thank you, Your Honors.
Back to Mr. Rogan.
Yes, thank you, Your Honor. Just a couple of points. One, just to follow on with what Justice Moulton said, yes, we believe that we have more than sufficiently alleged interference with the practice of medicine and with her discretion as laid out, such that at least on summary judgment, there was a material question of fact as to whether a prior breach occurred that should have warranted denial of summary judgment in plaintiff's favor on the breach of contract claim. And seizing on something that Mr. Kuttner just said, no, we are not conceding that Dr. Epstein resigned rather
than... but even if you're not conceding, Mr. Rogan, there was a prior action where you were the plaintiff and you went to court first, and the same judge had that case, and she made a finding that your client resigned, And isn't that collateral estoppel? I mean, you can't really fight that here. We already have a finding in another case where a judge already made that finding and there was no appeal. There may have been a notice of appeal, it looked like to me, but it was never perfected.
Your Honor, no, there is no collateral estoppel effect, because in that case, that decision was made on a 3211A1 pre-answer motion.
Yeah, but so what? It was a finding by the judge nonetheless.
Well, right, but there was no, but the one of the linchpin of the collateral was a full and fair opportunity to litigate the issue in dispute. And there, the only issue in dispute on the motion, on a 3211A1 motion, was whether or not the documents proffered by the defendant in that case, Mr. Feldman, utterly refuted the plaintiff's allegations. We opposed that because we didn't think on the face of the emails that they set forth that they satisfied their burden on a 3211A1 motion, but that does not convert into a finding that Dr. Epstein had a full and fair opportunity to actually litigate the issue of termination versus resignation. There's no way there should have been collateral estoppel given the complete absence of such an opportunity. And if that's the case, then it's another reason why summary judgment should not have been granted on plaintiff's breach of contract on the notice claim, and why defendant's claims should not have been dismissed based on that finding.
Thank you. Thank you both.
Thank you.
BGC Partners versus Avison Young.
Good afternoon, Your Honors. May it please the court, my name is Emily Milligan and I represent the appellant and cross respondents, BGC and its subsidiaries. This case has been before the court before.
I'm glad you mentioned that. Let's start there. So
Yes.
when it was here, and there are two justices on the panel who were both on that case, didn't the court here dismiss the trade secrets and the aiding and abetting claims?
That's correct. So
So at the time then that you had the second amended complaint, was there any complaint left to amend since this had already been dismissed?
So as indicated in our briefing, our understanding and the trial court agreed with us that the April 2018 order by this court dismissed those two claims without prejudice to replead. And that,
But it didn't say it. I mean, I know I read the transcript and I know that's what Judge Friedman said, but certainly the decision did not say that. I mean, it's not, I have the decision. I wasn't on the bench, but it didn't say that.
So correct. So the decision was silent as to whether it was a dismissal on the merits with prejudice. It was silent. The rule in New York under CPLR 5013.
Except 5013 speaks to a judgment, and this was an order. It was for the lower court to enter judgment. We issued an order, right?
The first department issued an order, correct? When the trial court received that order, the judge entered an order dated October 30th, in which she gave the plaintiffs the opportunity to amend within 30 days because she had questions about whether at that point the order from the first department had been with prejudice. She asked for briefing on that issue from the parties, gave the plaintiffs 30 days to amend, and said that
I just have to interrupt. I'm sorry. But in that decision, which didn't give you leave to amend, and my experience always is if that you're going to give leave to amend, you say with leave to amend. You don't leave it up to like somebody to figure out. The prior decision from this court also said that the court, meaning the trial court, is directed to enter judgment accordingly. So that means that there was nothing left of the case. And what we were saying is Supreme Court, New York County, and it's not the judge, but the clerk, should enter a judgment dismissing the case in accordance with our decision, which dismissed all the remaining causes of action. So it seems to me that you did not have any complaint, unfortunately, left to amend at that time. And that's the way I understand the procedure.
So the under CPLR 5013, which the first department has applied to its own decisions in the Aetna case, it makes clear that without a doubt that decision by the court in April of 2018 was without prejudice. So where did that leave us? If, as Your Honor suggests, the trial court was required to enter an order and judgment based on that dismissal without prejudice, then the plaintiffs would have had, because it was a dismissal without prejudice, we would have had the right within 6 months to replead and file a new case.
I understand that the Aetna, this has been applied in the Aetna case, but if you look at 5013, it does speak to a judgment, and ours clearly was not a judgment. I don't know any other cases other than the Aetna case that would have applied it this way. So, one really has to look carefully at how the language in that. But no one requested a clarification of the decision. No one requested that of this court. And understanding what you're saying, I still have the same question I started with was, if it didn't say, if we didn't leave anything to be amended, and I understand what you were looking at, but if we didn't leave anything to be amended, how would you be in a position to then, there would be nothing there to do a second amended complaint?
Well, our position and the trial court, I think, in her thinking and entering her order was that if this was a dismissal without prejudice, that the parties had an option at that point to replead in the same case, or the judge could have entered judgment, which has not happened yet. So the judgment has not been entered because we've been going through this motion practice. So there is no judgment yet. So if we end up in, the point is we end up in the same place no matter what, because when judgment enters, if the court finds that that's what should have happened and the judgment is entered, we then have 6 months to replead. The Third Circuit has actually looked at this issue before, and we cite the Amsterdam case in our brief. And there, the opposite was being argued by the defendant. The defendant complained that the plaintiff should have repled instead of filing a new case in that case, the Amsterdam case. The Third Circuit said it didn't matter because you end up with you either end up with a new case with a new file number, or you end up with a repled complaint in the same case. So it is in the end a distinction without a difference. If the trial court was mistaken, as you're suggesting, I don't think she was. I think that she interpreted the order from this court as a dismissal without prejudice under CPLR 1530, and that she believed that that allowed her to permit a motion for leave to amend.
I think you meant to say 5013, but I understand.
5013.
Thank you.
Yes.
Mr. Kreitzer?
Yes, may it please the court, Nate Kreitzer on behalf of the appellant's cross respondents. I think we really are focusing on what's relevant in this case, and we think it's really quite simple. There's a prior order from April of 2018 that we've been talking about, we've been discussing. Two of the judges on this panel were on that panel as well. The direction from the court is to alter the trial court's order solely to the extent of dismissing 3 additional causes of action from the 6 that were initially dismissed, and to enter judgment accordingly. The trial court's order that was entered in July of 2016 was entered with prejudice. The plaintiffs argued vociferously on appeal. This was not left alone. They argued vociferously on appeal as the very first argument in their opening brief. It should not have been entered with prejudice. The court rejected that argument. It affirmed that aspect of the trial court's order and directed the trial court only to dismiss 3 additional causes of action. So from our perspective, there really isn't a lot to clarify. The trial court was required, in consistent with this court's directions on remediator, to dismiss those 3 additional causes of action, add those to the order that had previously been entered, and enter judgment in accordance with the court's order. Now, I've heard a lot of contrary arguments from opposing counsel. I want to respond to some of those briefly. First of all, I think that Justice Renwick and Justice Kapnick have it exactly right, that there really is nothing left to amend here, particularly given the direction to enter judgment. I think that is so critical. It's hard to understand what a court is to make of a direction from this court to enter judgment if what that really means is, take it back and give them a chance to amend. That those 2 directions are very at odds with one another. Counsel is relying very heavily on CPLR 5013 and the Aetna case in particular. Well, in the Aetna case, the difference was very significant. In the Aetna case, the trial court judgment itself, not the order, the trial court judgment did not state whether it was with prejudice or not. And the appellate division chose to leave that unchanged. Here, we have just the exact flip side of that. The trial court order below, I suppose you might say it's not a judgment, but it was the order that the trial court entered below in July of 2016, stated that it was with prejudice. And the appellate court, this court, chose to leave that language alone. So Aetna really doesn't speak to this situation where you have a trial court order entered with prejudice, that language is litigated, that language is affirmed, and then someone argues on remand that actually, no, the appellate division's order is without prejudice, and we can amend because the appellate division didn't say with prejudice, even though the trial court did. Counsel argued that there was an option to replead or the court could enter judgment. I think that's just irreconcilable with what this court's order states on April 2018, which states that the trial court is directed to enter judgment. It's not an either or. And as to counsel's argument that we end up in the same place no matter what, of course, we couldn't disagree more strongly. On that point, the trial court's judgment was, or the trial court's order was with prejudice. We understood the appellate's division's order to have upheld that language, to have dismissed the additional claims. There's no 6 months to replead if your claim is dismissed. What counsel is referring to in the Amsterdam case is a lawsuit where someone brought a follow-on suit and complained that somebody didn't amend. It's just an opposite. It has nothing to do with the posture before this court. The New York legislature has not treated an amendment as being the same thing as filing a new lawsuit, nor is it. And that argument really has no force. I'm happy to answer any questions the court has about the.
Thank you. Any further questions? Thank you. Ms. Mulligan, we're back to you.
So if I can just respond to a few things that Mr. Kritzer said. So first of all, the trial court did dismiss a number of claims initially in 2016 with prejudice. These two claims were not dismissed. They were upheld by the trial court. This court reversed and remained silent as to the merits. It did not say anything about that. This court did that 3 times. 3 times the court remained silent about whether the dismissal was with prejudice because there was a motion to re-argue by both parties. So there were 3 orders that came down. When the final April 2018 order came down from this court, the First Department was aware by then that we were already having this fight about the with prejudice language, and the defendants asked for the language to be inserted, and the First Department did not insert it. That was a signal that the meaning here was a dismissal without prejudice. The with prejudice language never applied to these claims because they were not dismissed by the trial court. So the with prejudice decision by the trial court is just inapplicable. It never applied to these 2 claims. That's number 1. I mean, CPLR 5013 is not limited in any way. This is a rule that applies whenever there's a dismissal on the pleadings before the close of evidence, which is exactly what happened here. This rule applies. So the silence was an indication that this was without prejudice. And a contrary finding now is frankly very prejudicial to the plaintiffs because they have made decisions about this case based on the understanding that this was a without prejudice dismissal. Decisions about appeals, decisions about refiling a new case. I mean, our position is that because judgment was never entered, we can still file for leave to appeal to the Court of Appeals. We could still file a new case. I submit to the court that that ends up creating some wasted time because, and I would like to have a few minutes to talk about the underlying claims, we have actually cured the pleading deficiencies that this court found when they issued their prior orders. I mean, when you look at the—
Could you have brought a new action?
Sorry?
I asked whether you could have brought a new action.
I think we can bring, my understanding is we can bring a new action because this was a dismissal without prejudice. So we will have 6 months under CPLR 205A to file a new case. If that's what we are required to do by the court. We have cured the pleading deficiencies.
Now, of course, Judge Friedman did not agree with you on the merits anyway. That doesn't mean, you can't argue it, but she did not, right? She did not feel, in fact, that you had cured the deficiencies, correct?
Correct. So I would like a few minutes to address that point. We do think she applied the wrong standard. She was looking at whether the complaint as amended was materially different from the prior complaint. She decided it wasn't. What this court actually found in its April 2018 order was that we had not alleged wrongful means for the trade secret claim because competitive compensation offers to the brokers were not wrongful means. We have now amended that because of discovery that we received from the defendants in the case in the interim. So we now have the documents that are appended to our briefing that should actually demonstrate the trade secret misappropriation. And these documents that are voluminous. They show brokers sending Grubb and Ellis's confidential information directly to the defendants. They show that the defendants were asking for the information. They show the defendants were actually participating in the theft, and that is wrongful means. And the very important case that just came down from this court on this issue is Mere Enterprises, which we cite in our briefing. And that case is on point because that case involved, as is the case here, it involved defendants who did not directly have confidentiality agreements with the plaintiffs. And this court found that even in the absence of those direct confidentiality agreements, you could show wrongful means if the defendants were aware that the information that was disclosed to them was being disclosed in violation of the disclosing party's duties. And that is precisely what happened here. These defendants were completely aware that the information they were receiving from the brokers belonged to Grubb & Ellis. They knew that Grubb & Ellis considered it to be trade secrets and confidential. Why did they know that? Because the people leading this raid on Grubb were the former CEO of Grubb, the former in-house counsel of Grubb, and the former chief strategy officer of Grubb. They all worked at Avison Young. They knew what Grubb's contracts looked like. They knew about the confidentiality provisions. They knew the brokers had duties of loyalty to Grubb and that those duties of loyalty are actually in the handbook and the broker manual. The materials that were taken by the defendants are clearly Grubb's materials. If you look at the Beaudet affirmation and all the materials appended to it, they say Grubb & Ellis all over them. It is clear what happened here. This was very intentional conduct. Under the Mere case, we have alleged wrongful means. With respect to aiding and abetting
I'll
claim,
give you 30 seconds. I don't think you can hear me, or
I can hear you.
That or you're not paying attention. But I'll give you 30 seconds because I gave 2 minutes for rebuttal. I've already let you go over.
Okay. On the aiding and abetting claim, the same thing. The court found that offers of competitive compensation to the brokers was not substantial assistance in the breaches of the broker's duties of loyalty. We now know that all sorts of things happened, that Avison Young actually was deputizing brokers at Grubb to solicit their coworkers, and that in that way they were interfering with the broker's duties of loyalty. They were assisting in the breaches of confidentiality agreements, which are also imposed a duty of confidentiality on these brokers. So the aiding and abetting claim has also been cured here.
Thank you.
Thank you.
Mr. Kreutzmann?
Thank you. If I may just respond, I'll be very brief to the points counsel just raised. So first of all, as far as the claim that silence was somehow an indication that this court meant to dismiss without prejudice, obviously we don't agree. The court was not silent. In fact, the court expressly rejected the plaintiff's argument that the with prejudice language from the trial court order should be removed. And what we argued, in essence, in the follow-on briefing on motions to clarify, or motions to re-argue rather, was that the court should send a clear signal that the case is done. In the next order that the court entered, it stated that the trial court was to enter judgment. And we interpreted that certainly, and of course the court can interpret its own orders, but we certainly interpreted that to mean the case is done, there's nothing left to do. That's what a judgment is. Following on to counsel's arguments that they've cured the pleading deficiencies, really they have not. They really put forward the same conclusory allegations the court previously found were insufficient. We attached an appendix A to our brief below, which the court can find at pages 1170 to 72 of the record, that compares what was alleged before, what's being alleged now, and exactly what the plaintiffs argued to this court, to show that effectively all the same allegations and arguments have already been rejected by this court. So we really don't think there's anything new here. The trial court was absolutely correct in saying that nothing really changed. Remember the next. Counsel cited Mere Enterprises to claim that that case supports our argument on improper means. Improper means were not at issue in that case. That case concerned the questions, first of all, of whether there even was a trade secret, and secondly, whether there was a trade secret that was used. The case that's really on point here is the case that the court cited previously, Schrader versus Pinterest. In that case, the court said improper means is a required element of a trade secrets claim, and you don't state a claim for improper means just by saying that somebody provided you with something, or that there's an element of persuasion alone, as the court stated in the prior opinion citing Guard Life. I also want to address very briefly the claim about aiding and abetting. I think there's both an issue there legally in that this claim, as they've articulated it on this appeal, is completely duplicative of the trade secret claim. They're essentially making all the same arguments. I think it has to be rejected on that ground. It doesn't plead anything new. But even more fundamentally, what they're saying is you recruited people to leave this company, or you got people to recruit other people to leave the company in breach of a duty. First of all, recruiting is an ordinary activity that is not substantial assistance under Kaufman versus Cohen. And secondly, just coming down to just the most basic facts here, the company was in bankruptcy before any of these folks left. The earliest person to leave was Vint Carriga, and if you look at page 1948 of the record, his departure date was April 25th, 2012, more than 2 months after Ravenel's filed for bankruptcy.
Thank you.
That's all I have. Thank you.
Thank you both.
Thank you.
Nimble Ventures versus Graves.
Good afternoon, Your Honors. Chris Harwood for Appellant Michael Graves. Can I please reserve 90 seconds for rebuttal?
Okay. I'm going to round it off. You can either have 1 minute or 2.
2, please.
Okay. That's 4 and 2.
May it please the court, Mr. Graves is here today because in denying the motion to compel arbitration and denying him of his bargained for right to have his dispute with Nimble over matters relating to Liquid Digital, a Delaware limited liability company, resolved through confidential arbitration, the Supreme Court decided 2 issues of arbitrability that it should not have reached. And as the Delaware Court of Chancery previously held, after evaluating the same issues under the same arbitration provision, properly should be decided by jams. Those 2 issues of arbitrability that the Supreme Court decided are, 1, whether Mr. Graves is entitled to enforce the arbitration provision in the parties' LLC agreement, and 2, whether Nimble's claims against Mr. Graves fall within the scope of that LLC agreement or a separate loan agreement to which neither Mr. Graves nor his trust is a party. Now, regardless of what law applies, the FAA in Delaware, as Mr. Graves has shown, or New York law, as Nimble incorrectly argues, those are both issues of arbitrability under the settled law. So the only question then is whether those claims, those issues of arbitrability were reserved for jams. And again, regardless of what law applies, the LLC agreement's arbitration provision contains language that courts routinely recognize reflects the parties' clear and unmistakable intent for issues of arbitrability to be decided by jams. And that is the well-established exception to the general rule that courts decide arbitrability. Now, Nimble doesn't challenge either of these points, that the issues the court decided are issues of arbitrability, and that under the LLC agreement, issues of arbitrability are reserved for jams. Nimble's only response is to try to defend the denial of the motion to compel by arguing that its claims against Mr. Graves arise not under the LLC agreement, but under a separate loan agreement. Now, that's a manufactured argument. The initial complaint that Nimble threatened to file against Mr. Graves, and that is before jams right now, contains the same exact allegations against Mr. Graves as the complaint here, and seeks the exact same damages relating to Nimble's debt and equity investments in Liquid Digital as the complaint here. And it makes no claim under the loan agreement. Now, the lack of any claim under the loan agreement makes perfect sense, because neither Mr. Graves nor his trust was a party or had anything to do with the loan agreement. By contrast, Mr. Graves, through his trust, was a party to the LLC agreement. And it was the LLC agreement that governed his business relationship with Nimble. Nimble only added the breach of the loan agreement claim after the jams arbitration was already initiated, so it could try and argue what it argued here, that the claims against Mr. Graves somehow arise out of the loan agreement. But the manufactured loan agreement argument fails for a number of reasons. But first and foremost, and the one that this court can stop at, is because to resolve it would require this court to decide the same issue of arbitrability that the Supreme Court incorrectly decided. That is, whether Nimble's claims against Mr. Graves arise under the LLC agreement and therefore are arbitrable, or under the loan agreement and therefore are not. Now, under the settled law we cited, whether a claim arises under an agreement with an arbitration provision or a later agreement, a separate agreement without one, is itself an issue of arbitrability. The court should stop there. But besides raising an issue of arbitrability, Nimble's loan agreement argument also fails for the other reasons we've briefed, two of which I'm going to highlight briefly. First, Nimble's core allegations and claims against Mr. Graves necessarily arise under the LLC agreement and have nothing to do with the loan agreement. Nimble alleges that Mr. Graves fraudulently induced it to make an equity investment in Liquid Digital and that he misappropriated money from a Liquid Digital bank account. Now, those are false. We'll ultimately show that in litigation, but those allegations, which Nimble has no choice but to ignore, it ignores them entirely in its briefing, necessarily arise under the LLC agreement because by its express terms, the LLC agreement, not the loan agreement, governed Nimble's equity investment in Liquid Digital and the Liquid Digital bank account.
What counsel, what dispute is there amongst these parties related to the loan agreement, which I know does not have an arbitration provision? I mean, are other claims in this case related to the loan agreement as opposed to this cause of action you're talking about?
There is one claim that's been alleged under the loan agreement, and that is a claim against the co-defendant, my co-appellant, Liquid Digital. That is the only claim that has been alleged under the loan agreement.
So there are 5 causes of action here. There are 5 causes of action here. The first one is Liquid Digital's breach of the contract, breach of the loan agreement. And then all the others, 2 through 5, you're saying relate to Digital or Graves with regard to the misappropriation, I think, or those other matters, misrepresentation and such. Is that what?
Yes, Your Honor. Count 1 is a breach of contract claim by Nimble against
referring to the loan agreement, which doesn't have the arbitration as
under the loan agreement.
And the other 4 you're alleging are the LLC agreement, which has the arbitration agreement.
They necessarily arise under the LLC agreement, which has the arbitration provision, because they necessarily touch on matters that arise out of the LLC agreement. The misrepresentations that led to equity investments.
Okay.
What I will say is, even with respect to, if there are one more point, Your Honor, very briefly. Even if there are some allegations that somehow could be construed or claims that arise under the loan agreement, they would necessarily be appropriately stayed. The motion to compel arbitration would be appropriately granted because all of Nimble's allegations are premised on the same underlying conduct by Mr. Graves. And so that underlying conduct is going to be at issue for claims that necessarily are subject to determination by JAMS as to arbitrability. And if it finds arbitrability, they'll be arbitrated. And so under the settled law, given that, even if claims arise under the loan agreement, they would necessarily appropriately be
Let's
stayed.
hear from Mr. Cole. Otherwise, I have to take away one of those minutes you asked me to reserve.
Thank you, Your Honor.
Mr. Cole, you're still on mute.
Sorry, Justice Rehnquist. May I please reserve 1 minute, please?
1 minute, okay.
And I'd like, if it's okay with you, Justice Rehnquist, to go back to something that you asked about and to stress what the loan agreement is and how it impacts the LLC agreement. It is true that the loan agreement does not have in itself have an arbitration provision. However, the loan agreement
does not mention Mr. Graves, I think.
It does not mention Mr. Graves, but it was signed by Nimble and was signed by my clients. What's important, though, is not so much what the loan agreement says, but what the LLC agreement says, and what the claims are in the arbitration in Delaware. So it is true that the loan agreement doesn't have an arbitration clause, but all the breaches that are alleged in the loan agreement are claims that arise and relate to the LLC agreement, which contains the arbitration provision. And you could see that in 2 different ways. First, the loan agreement at section 4.3K and 4.1L is dependent, its entire existence is dependent on the LLC agreement. Those two agreements are intertwined. They were signed by the same parties. They were signed on the same date. They were signed as part of a singular restructuring of an investment. The claims that are made in the arbitration that Nimble actually filed or served in a draft complaint to Liquid Digital all arise out of the loan agreement, and they say that, for instance, the Liquid Digital failed to provide financial statements in accordance with GAAP. That was something that the court found was a breach of the loan agreement, which falls within the LLC agreement and is brought as part of the arbitration. Liquid Digital entered into a related transaction with Mr. Graves, which is something that is the breach of the loan agreement, but falls within the scope of the LLC.
Well, wait a second. I'm a little bit confused. So the first cause of action is specifically against your client Liquid for breach of the loan agreement. That's clear. But the second through fifth causes of action are, I know there's negligent misrepresentation and unjust enrichment. And things that, it doesn't mean that we don't know that the loan agreement exists, but it's not specifically, related directly to the loan agreement, and that parties are entitled and very often do enter into more than one agreement when they're, creating some kind of a business structure, a loan agreement, an LLC agreement, a bunch of others that have different provisions, different signatories, and whatever. And so I don't know. I think you're trying to confuse the issue here a little bit.
No, Justice Cabinet, if I may. I agree with you that when parties enter into separate agreements, they can intend them to be separate. But when parties enter into a group of agreements as part of a singular transaction and refer and relate to between the agreements, signed by the same people, on the same date, those agreements are interwoven, and the disputes in those agreements are considered interwoven. To the extent there are disputes.
Yeah, but I mean, with the arbitration provision, I don't know if you were here at the beginning of this afternoon, but arbitration provisions have to be very, very specific. And if one of these agreements has an arbitration provision and another one doesn't, we have to, be able to make this distinction. They're not so interwoven.
Correct, and that's correct, Your Honor. But what that leads to is when a claim is made between the parties, and the arbitration agreement leaves for the arbitrators the question of arbitrability and whether or not a particular claim is arbitrable or whether it's been commenced properly. That's an issue of contract interpretation in the contract in which the arbitration provision appears. So in this case, when we talk about arbitrability and we talk about arbitration of these claims, we have to separate what's going on here. The first issue, the predicate issue that has not yet been determined, or that the motion court determined that should have been determined by the arbitrator in the first instance, is whether or not any of these claims are arbitrable under the arbitration agreement and the LLC agreement. That's what should have happened, and that's what SACRO says. That's what the first option says. That's what all the cases that we cite in our briefs say, that when you have an arbitration agreement between two parties arising out of a unified transaction, the issue of arbitrability is determined by the arbitrator, where the arbitration provision provides for a specific set of rules that designate the arbitrator to determine arbitrability. It is true, Justice Cabinet, that if the arbitrator were to determine that the loan agreement is a separate agreement, then perhaps you're right. It would have to be litigated separately, and it would have to be litigated in New York under the terms of that agreement. But when you talk about these other, the other claims as well, my client is not a defendant in counts 2, 3, and 4. But count 5, for example, is a fraudulent transfer claim that relates to claims that that money was taken out of the company in a manner that was inconsistent with what the LLC agreement provided, and maybe what the loan agreement provided. The intertwinedness of those agreements And the overlapping issues in the arbitration and in the New York case compel that the arbitration goes first and arbitrability be determined first. And it's not for the court to decide. And I think, Justice Kapnick, earlier on, that was one of the issues that came up, was that the court has the first dibs on determining arbitrability. In this case, that's not the case because the parties agreed that the arbitrator decides arbitrability.
And didn't the Delaware court already determine that?
Yes, and that goes to the second part of this issue. And respectfully to the courts in New York, when a sister state court rules on the very issue under the very law that the parties agreed would apply, and issues a ruling that says the arbitrability is for the arbitrators, it behooves this court to grant comity to that court, particularly given the fact that it was under that court's law and that court came first. And in this case constitutes, in essence, a collateral attack against the Delaware court's decision.
Thank you.
Arbitrability should have been determined first.
Thank you. I think we go to you, Mr. Mullen.
Good afternoon, Your Honors, and may it please the court. Wesley Mullen for the respondent, Nimble Ventures, LLC. This is a case about the breach of a loan agreement. And I want to be clear that all of the respondent plaintiff's claims are about and are brought in relation to the loan agreement. The appellants here seek reversal.
Hey, counsel, it's Justice Moulton, just to interrupt you. Counts 2 to 5, do they seek any return of the loan proceeds?
They do, Justice Moulton.
They do?
So count 1, as Your
Count
Honor
1 does, but I'm talking about 2 through 5. Do they seek any return of the loan proceeds? And if not, then how can you say they arise under the loan agreement?
Yes. So counts 4 and 5 are for fraudulent transfer. My client alleges that it loaned $8 million to the defendants, and that those defendants and their executive, Mr. Graves, who is also an appellant here, took that money and fraudulently transferred it, including to Mr. Graves's bank account and to other entities that Mr. Graves controls. Counts 2 and 3 are claims for fraud and negligent misrepresentation. And what my client is alleging there is that the defendant borrowers and Mr. Graves made false or negligently misleading statements that induced the loan, right? Induced the lender to give $8 million to the borrowers here. So what my client has claimed and why it has pleaded all of these claims together, along with its straightforward claim for breach of the loan agreement, is that these are other claims that naturally go together with, arise under, and are in connection with a claim for breach of the loan agreement. And that's why they're all together before the Supreme Court. If I may, the appellants here seek reversal of multiple orders, and this court should affirm all of them, along with the judgment entered by the Supreme Court.
What do we do with the Delaware court? What do we do with the ruling made in the Delaware court?
You may allow the Delaware court's ruling to be what it is, because the Delaware court interpreted the LLC agreement, which simply does not apply to claims that arise under the loan agreement. There's only one party here that's filed any claims, and that's my client, Nimble Ventures. The defendants, who very much desire to have any claims resolved in a confidential secret arbitration, have attempted to plead for a declaratory judgment as to claims that my client never filed in Delaware to inspect the borrower's books and records. That was before we knew there had been a breach of the loan agreement and before Nimble Ventures sued for breach of the loan agreement here in New York Supreme Court.
You just said that your client he put $8 million into this, but in 2 through 5, I see reference to 1.4. So it isn't really the bulk of this, your action, your first cause of action to the remaining funds? I mean, isn't that really where?
Your Honor, let me see if I can clarify, and you'll forgive me because I'm reverse engineering the numbers you've given me. Count 1 is for the entire amount of the loan agreement. We're saying you breached the loan agreement, so give us our money back plus interest.
Right.
That's been determined by Supreme Court. The justice entered judgment in the principal amount because we waived interest. The 1.4 to which Your Honor is referring
is the embezzlement, for example.
Yeah, it's the money that we know.
The negligence, yes, right. Okay.
We saw the borrower's bank account statements. We can say, wow, these are transfers unauthorized by the borrowers that went to an executive of the borrower, that went to these, what we believe are shell companies, and we know that money is fraudulently transferred. So it should be given back to the borrower, and we should reclaim it because
But
those
counsel,
are
aren't all
funds.
those are all tort claims? Aren't they all tort claims? I mean, they're not really arising underneath the loan agreement, are they? They concern loan funds, you're saying, but do they arise under the loan agreement?
Sure, they do arise under the loan agreement, Your Honor. And at pages 23 and 24 of the respondent's brief, we cited case law for the proposition that a forum selection clause, a judicial forum selection clause like the one in the loan agreement here, necessarily encompasses claims, including tort claims, that are brought in relation to the contract and or which arise out of the business relationship. And I'm quoting.
Counsel, this is Judge Owen, building on what Justice Moulton just said. Supreme Court awarded you judgment on the loan agreement, yes?
That's correct, Justice.
Right. So you're made whole with respect to that loan agreement.
I would that my client were made whole, Justice Owen, but as it turns out, there are only about $1.5 million left in the borrower's bank accounts.
I understand that. You have a judgment on paper. Always the dilemma is trying to collect the judgment, correct? I mean, that's always the problem, right? You get a nice paper that says you got judgment. Yeah, you got to find the money. So that essentially you're made whole in theory, okay? So that, as Justice Moulton says, all the other counts 2 to 5, those are all like, bad acts that the defendant committed, Mr. Graves and his accomplices allegedly committed, that you're seeking recovery on. So that's separate and apart from the loan agreement. That arises out of the LLC, which has all these fiduciary obligations, and they have to respect each other. You have to, duty of loyalty and all that. That's kind of separate from the loan agreement, don't you think?
To respond to that, Justice Owen, I agree that we're seeking to recover based on bad acts of the borrowers and their executive. Right. I don't agree, and my client doesn't agree that that's separate and apart from the loan agreement, or that, as the appellants here claim, it arises under the LLC agreement. For one thing, Mr. Graves, who's an appellant and defendant, is not a party to any of the LLC agreements. Mr. Graves is not a party.
No, that's not actually correct, because his entity is a signatory to the LLC, correct? The entity that he controls, FTC?
Mr. Graves owns an entity that is a party to the LLC agreement. He also owns shell companies to which he fraudulently transferred millions of dollars of the borrowed funds.
So he is a signatory not through himself, but through his entity.
That's correct, Justice Swing. And if one of those entities had attempted to file the arbitration that's at issue here, and by which Mr. Graves is attempting to throw this litigation into a secret arbitration, he might have a claim. But as it turns out, he does not, because he does not have the right to compel arbitration under the LLC agreement. Only the LLC.
No, but didn't the CEO say it was okay? Go ahead, let's do this. That was that's what Delaware court made reference to, the March 16th letter or email saying, yeah, go ahead, let's do this. Let's go to arbitration. And then he retracted it. And then later on, Mr. Graves got control of the board and then sort of reaffirmed what the CEO did to go to arbitration. I mean, it's a lot of stuff going on.
Let me try and make this clear, Justice Owen. The LLC rejected arbitration twice. Mr. Graves filed an arbitration. He said it was on behalf of the LLC, and the LLC says, no, we did not do that.
No. Before he filed the arbitration, the CEO who resigned, sends him and says on March 16th, go ahead and file it. And then on March 17th, that's when he commenced the arbitration proceeding. That's when Graves commenced the arbitration proceeding, sort of on behalf of the LLC, because he's got the permission to go. And then after that, we had all the fallout afterwards.
If I may, Justice Owen, to be very clear about the timeline, the CEO, before any action was filed, said, if any case proceeds to litigation, I'm going to elect to arbitrate. Mr. Graves then goes ahead and arbitrate, but nothing had been litigated. And then at page 525 of the record, the CEO of the LLC writes that the LLC does not elect arbitration. And then at page 646 of the record, the lawyers of the LLC write to the arbitrator herself, and they say, we didn't file this arbitration. We didn't give Mr. Graves permission to file this arbitration. Only the LLC can arbitrate, and the LLC has chosen not to arbitrate.
And that's what the Delaware court found in favor of saying you're going to arbitration.
The Delaware court said that to the extent there's been an election to arbitrate under the LLC agreement, which my client says is not at issue in New York, but that question has to be answered by an arbitrator. So whether Mr. Graves who took this ultra vires action to commence an arbitration. Whether he did that properly is a question for the arbitrator.
You know what? You can say that, but you got that March 16th letter from the CEO. And you have ultimately, when he takes control of the board, that they reaffirm and say, let's go to arbitration, unless I'm missing something. You have
Again,
those two factors thrown into this mix here.
Yeah, forgive me, Justice Wang. Again, it's pages 525 and 646 of the record, where the LLC clearly says to the arbitrator, we don't agree to arbitrate, and Mr. Graves is not allowed to arbitrate on our behalf. This is the guy who stole all the money that Nimble's trying to get back.
Are there any other questions from the panel? Thank you, Mr. Mullen.
Thank you.
Mr. Harwood?
Thank you very much. I want to start by saying the allegations and the discussion by my opposing counsel are precisely the reason why Mr. Graves is attempting to get to arbitration, because nothing has been proven. Nimble is speaking like he has been found to have engaged in misconduct. He didn't. There's evidence in the record that he didn't. But this is exactly why we're looking for arbitration. Now, whether the claim arises under the LLC agreement or the loan agreement, that again is an issue of arbitrability. As has been recognized, the Delaware court held this. It analyzed the same agreement, it analyzed the same issues, and it held this question, the precise question that Mr. Mullen for Nimble is arguing here, is an issue of arbitrability that the arbitrator must decide. Now, Nimble is wrong that its claims arise under the loan agreement, but again, this court shouldn't go there, whether it arises under the loan agreement, whether it arises under the LLC agreement, because as the Delaware court held, that's an issue of arbitrability for JAMS. The claims did, however, arise under the LLC agreement, even if that were relevant here. Mr. Graves is not a party.
I mean, how do these claims actually arise out of either of the agreements? They're, as we've said, they're tortious, fraudulent transfer, negligent misrepresentation. They don't. Those are not contractual claims. Those are tort claims that are separate and apart. I'm not saying there won't be a reference to the agreements. I mean, we know they exist. It's part of the picture that we're going to look at. But how did those kinds of acts arise out of a contractual agreement? Those are separate tortious actions that are alleged, I believe.
To the extent that an agreement is relevant to Mr. Graves, it must be the LLC agreement, because the LLC agreement governed his relationship through FTL to Nimble. It governed
but how could the loan agreement, which is how they got involved with the $8 million, and how could that not be involved?
Well, Mr. Graves is not a signatory to the loan agreement. He's not a party to the loan agreement. FTL is not a party to the loan agreement.
Yeah, but he is the CEO or something of Liquid, and that's who he loaned the $8 million to.
He's not the CEO. He's just a co-investor. He's the same position as Nimble is. They are co-investors in Liquid Digital. There was an entirely separate arrangement between Nimble and Liquid Digital where Nimble loaned money, but that had nothing to do with FTL or Mr. Graves. Importantly, Nimble has asserted claims that it was fraudulently induced to purchase equity in Liquid Digital. Any purchase of equity under the terms of the LLC agreement are governed by the LLC agreement. Nimble has alleged that my client misappropriated funds from Liquid Digital. Right. The bank accounts, the conduct on the bank accounts, that's governed by the express terms of the LLC agreement. The LLC agreement therefore touches the claims in a way, with respect to Mr. Graves, that the loan agreement does not and cannot possibly, because he's not a party to it. And so it's wrong to suggest that the damages, the claims somehow against my client arise under the loan agreement when the subject matter of those claims is governed by the LLC agreement. My client agreed to a business relationship with Nimble under the LLC agreement, and the LLC agreement has an arbitration provision. And so then the question about whether those claims relate to the LLC agreement and are arbitrable, or the loan agreement and are not, necessarily raises a question of arbitrability. And Mr. Graves has the right to invoke that arbitration provision because FTL, his entity through which he participated in Liquid Digital, is a party to the LLC agreement. And so as the sole director control person, both under the law and under the LLC agreement itself, how the agreement defines the term control person of the entity, he has the right to invoke the arbitration provision. And he also had the right to file for arbitration. Liquid Digital.
If you would wrap up and let me hear from Mr. Cole.
Yes, the last thing I'll say is Liquid Digital elected to arbitrate. Liquid Digital is the only party that can elect to arbitrate, but once it elects, the LLC agreement makes clear that it's not the only party that can commence. And so my client properly commenced the arbitration after Mr. Whalen elected on behalf of the company to arbitrate the dispute. Thank you.
Mr. Cole.
Thank you, Your Honor. I'd just like to go back to Justice Kapnick's question. In a nutshell, claims 2 through 5 are tort-type claims, but they all deal with the manner in which the LLC is being managed, how money flows through the LLC, how money goes out of the LLC. It's an LLC issue. The issues in those claims are how LLC is being managed. That falls within the LLC agreement. How that wraps back to the loan agreement is that when we deal with issues of arbitrability and whether or not something should be arbitrated, the question is whether or not the disputes are intertwined. All of the claims, all of the items that were mentioned as breaches of the loan agreement were the tortious acts that were claimed under the LLC agreement. That arbitration was commenced first, before the New York action. The arbitration was based upon claims that relate to the loans, the actions of Mr. Graves, and the other actions that are in the complaint. Those claims were set forth in a draft complaint that Nimble served on us and was submitted to the arbitrator. So the claims that are at issue under the loan agreement, and the reason why the motion court was incorrect in entering judgment without allowing the issue of arbitrability to be arbitrated, was that the identical matters, the identical disputes were already being litigated in JAMS. And therefore, the JAMS arbitration should have occurred first under the law as set forth in our complaint. And the issue of arbitrability should have been determined by the JAMS arbitrator first.
Thank you. Thank you all. This is the last case and court is adjourned. Thank you very much.
Thank you. Thank you, Your Honor.
Thank you very much.
Thank you. Good afternoon.